It was always my idea up until the time that Mr. Dulos passed away. I was trying to figure out a way to use her as a witness against him. I'm not very trusting. I'm not a very trusting individual, I would say.
Attorney Bowman's recommendation to meet with police on June 2nd and subsequent dates without protection was not reasonably competent or within the standard of care.
Is there a point early in the second interview where it became clear the police still didn't think Michelle was telling the truth?
Yes,
Why didn't you cut off the interview when that became clear?
because she was making progress
How so?
by the virtue of what she had told me before we went in.
Was there any discussion of, I'll say it broadly first, protecting Michelle during that interview that was raised to you by Attorney Bowman?
No, not that I recall.
Have you ever been in a position to give a public compliment to Attorney Bowman?
Yes, quite some time ago, 15 to 20 years ago, I paid him a compliment.
And was that in a public place or privately or?
Well, it was in the case of United States versus Giordano. I felt that he was being unfairly criticized. A newspaper reporter called me, and I defended him in the press.
Do you know if you were asked what your basis of saying that Michelle Troconis was responsible for being accessory to murder was at that point, what you had known at that time?
She was with him while he was dumping the items along Albany Avenue. If you looked at that video from Starbucks, she was obviously nervous in that video. And there was no sound, but just looking at body language, he was trying to calm her down. And she was obviously distressed or nervous in that video.
Morning, please be seated. The delay in starting this morning was due to circumstances beyond my control, but nonetheless, on behalf of the state of Connecticut, I apologize to everyone for having to wait this long. Counsel, are we ready to resume?
Yes.
Mr. Bowman, if you would.
Yes, sir. I'm still in the middle of my cross-examination of Attorney Bowman.
Good morning, sir. Please have a seat. And when you're ready, Mr. Zentner.
May I proceed, Your Honor?
May.
Okay. Welcome back, Attorney Bowman. When we were here last Monday, about 4 days ago, I had asked you, among other things, your background, and you had indicated that at one point you were appointed by the Chief Judge of the Second Circuit Court of Appeals to be the federal public defender for the state of Connecticut. Do you recall that?
Yes.
And you said that appointment was for 4 years?
Yes.
And that 4-year period concluded in December of 1979?
Correct.
Your Honor, I should note that during the recess, there was a revised list of exhibits that the clerk had presented to the parties. I think I spoke to Attorney Brown. By agreement, I think all of those, just to augment the record, could be admitted without objection from either side as full exhibits.
Is that correct, Mr. Brown?
That is correct, Your Honor.
So, defendants' exhibits A through T admitted in full, and plaintiffs' exhibits, there's at least one or two that are marked ID. Are you saying those are all coming in as well?
Yes, Your Honor.
All right.
Attorney Brown.
So plaintiffs' exhibits 1 through 26 admitted in full?
Yes, thank you, Your Honor.
All right. Thank you, counsel.
I appreciate that. Thank you, Your Honor. When you were at the end of your 4-year term in December of 1979 as a federal public defender, do you recall who was the Chief Judge of the Second Circuit Court of Appeals at that time?
Irving Kaufman.
Okay. And did you receive any kind of letter from Judge Kaufman regarding your time or tenure as the federal public defender?
Yes, I did.
May I approach the witness?
Court, you don't have to ask.
Oh, it's a tough habit to break. My apologies. I'm showing you from the record what's been now admitted as a full exhibit, Assistant B respondent or defendant's exhibit T as in Thomas. Do you recognize that letter, Attorney Bowman?
Yes, I do.
And how do you recognize it?
Well, it was given to me by Judge Kaufman, and it is a letter that I have kept in my office for all these years.
And Attorney Bowman, what is the date of that letter?
December 13, 1979.
And with the court's permission, Your Honor, it's relatively short. May the witness read the letter, please, for the record?
Yes.
Dear Mr. Bowman, I am sorry to learn that you will be leaving the post of federal public defender for the District of Connecticut, which you have filled so ably for nearly 4 years. I know that I speak for the entire Circuit Council in expressing our sincere gratitude and appreciation for the important public service you have rendered. Through your dedication, the constitutional rights of countless criminal defendants have been safeguarded, and the rights of all members of our free society have thereby been protected. Sincerely.
And it's signed by Judge Kaufman?
Yes.
Now, you also testified last Monday about your prior dealings with then State's Attorney Richard Colangelo. Do you recall that testimony?
Yes.
And to the best of your knowledge or memory, do you remember the last time you may have spoken to Attorney Colangelo?
Well, I was replaced as counsel for Mr. Troconis on the 3rd of February 2020. Mr. Dulos died at the very end of January, so it had to be sometime in January of 2020.
Okay. And you have, to the best of your knowledge, you have not spoken to him since?
No.
Now, as part of your representation of Michelle Troconis, were you aware that she was also going to be deposed in a civil matter?
Yes.
And do you recall the name of that particular civil matter?
The exact name, I can tell you generally who the parties were. It was the estate of Jennifer Farber's father, I believe.
And was his,
Against Ford.
his first name Hilliard?
Yes.
And his last name is Farber, for the record, Farber?
Correct.
And it was it versus Ford Group?
Yes.
Okay. And you were aware that she was going to be deposed at some point relative to that civil action?
And she had received a notice of deposition and I think a subpoena as well.
Okay. And in representing her in that capacity, did you file what is called an affidavit of Andrew B. Bowman, and that would be yourself?
Yes.
And did you indicate in that affidavit to the withdrawn, what was the purpose of that affidavit?
Well, they wanted to depose her. She was a defendant in a pending criminal case, and I was asserting her Fifth Amendment right to silence.
And did you express that assertion in that affidavit?
Yes.
And I'm sorry, Your Honor, I'll just approach the witness again. It's 36 years, it's a hard habit to break.
All right. Well, it's not a good idea to break good habits, I suppose. So you may be granted permission to approve.
Okay. I guess. I want to make sure I get the right exhibit for the record. Attorney Bowman, I'm showing you what has been admitted as a full exhibit for purposes of this proceeding. Defendant's respondents exhibit G as in Gregory. Do you recognize that document before you?
Yes.
Is that the affidavit you were just referring to in your testimony?
Yes.
Is that the affidavit that you submitted to the court or whomever as to why she was getting Mr. Troconis could avail herself of the Fifth Amendment in the deposition letter?
Yes, this was in the Superior Court for the Judicial District of Hartford where the civil case was pending. Yes.
So it's fair to say, all things considered, in this situation, in your representation of Ms. Troconis, you thought under the circumstances when it may be in her interest to speak to the police, and at the same time, when it may be in her interest to invoke the Fifth relative to the deposition. You
Yes.
drew that distinction as her attorney.
I did.
Now, you said you represented many criminal defendants over the years in private practice as well as in your capacity as the federal public defender, correct?
Yes.
Are you familiar what is commonly referred to as a proffer agreement?
Yes.
And how are you familiar with that?
Well, I've represented many people over the years and seen proffer agreements, both with respect to people against whom a client of mine might testify and proffer agreements that were entered into by clients of mine.
And is it more commonly used in your experience in federal court as opposed to state court? A formal proffer agreement?
The form of proffer agreement, state court has a cooperation agreement, federal court has a proffer agreement, which is not a cooperation agreement, but rather a limited protection that an individual who may be a defendant or not a defendant may be offered, which gives them protection against what they say being used in the prosecution's case in chief.
And with regard to a proffer agreement, what are the obligations of the person, the client, the defendant who enters into such an agreement?
The obligation is to be truthful, not to mislead, to be complete in what you're telling either the federal government or in this case it would be the state, not to commit any further crimes, and to be responsive to requests by the government.
Okay. And if the client or the person who enters into such an agreement is found to have lied, give incomplete answers, give misleading answers, what consequences flow from that type of misleading or untruthfulness?
If what an individual who is being interviewed under a proffer agreement deliberately lies about a material matter, not just a minor matter or through inadvertence, but intentional lying, the agreement is null and void, and the individual has no protection under the agreement, which means anything they say can be used against them.
And additionally, depending on what was said, they could be subject to additional crimes independent of the crime for which they were supposedly entering into an agreement for.
Well, they could be, they could be vulnerable to obstruction of justice, matters such as that. But the main thing is that the agreement itself is null and void, and therefore they do not have any protection from the use of what they have said against them.
Okay, Attorney Bowman, I'd like to show you in a moment or two what has been admitted as a full exhibit. State's Exhibit S has in Sam. And if you could, when I show it to you again, same questions I'll ask you, identify it and how you know about it. Okay, so for the record, I am now showing in front of you State's Exhibit S is a 2-page document and ask if you recognize it.
Yes.
And how do you recognize it?
Well, it's a standard federal proffer agreement that's used by the United States Attorney's Office in Connecticut.
And you've seen such an agreement in your experience?
For years, yes.
I would like to direct your attention to the second page of that document, S, paragraph 8. Can you read that, please? It's not too long.
It says, "It is understood that nothing in this agreement shall be construed to protect your client from prosecution for perjury, false statement, or obstruction of justice or any other offense he commits after the date of this agreement. And the statements and information your client provides at this meeting may be used against him without limitation in any such prosecutions. It is further understood that if the government determines that your client has intentionally provided false misleading, and inaccurate statements or information at this meeting, then this agreement will become null and void.
Now, I think you alluded to a reference early in your testimony that on the state level, you see what is often called referred to commonly as a cooperation agreement. Do you recall that?
Yes,
Okay. Have you seen those at the state level?
I have, but not with the frequency
Okay.
that I have seen at the federal level.
Please have a moment, please, Your Honor.
Yes.
I'd like to show you another document, also 2 pages, I'm sorry, 3 pages, but the substance is 2 pages. And for the record, I am going to show you what has been admitted as defendants or respondents exhibit K. Okay? Okay. I'm presenting before you. If you can just peruse that. Defendants exhibit K. If you can take a moment and look through that.
Yes.
Okay. So again, the same series of questions. How do you recognize it?
Well, I've seen it in at least one case where I think it was a case that my client was not the recipient of this.
And so directing your attention to, says page 2 of 3, beginning with the full paragraph. I'm going to ask you to read into the record the first 2 full paragraphs of page 2.
It is further understood and agreed that the witness must at all times give complete, truthful, and accurate information and testimony and must not commit any further crimes whatsoever during the pendency of this agreement. Should the witness commit any further crimes, or should it be reasonably determined by the state's attorney's office that he has given false, incomplete, or misleading testimony or information, or has otherwise violated any provision of this agreement, he shall thereafter be subject to prosecution for any state criminal offense of which this office has knowledge, including, but not limited to, the offenses described above, perjury and hindering prosecution. Any such prosecution may be premised upon any information provided by the witness, and such information will be used against him. Furthermore, it is agreed that in the event that it is reasonably determined by the state's attorney's office that the witness has violated any provision of this agreement, all of his statements to this office or to other law enforcement agents and any testimony that he provides before an investigating grand jury or other tribunal, whether provided prior or subsequent to this agreement, and any leads derived from such statements or testimony shall be admissible in evidence in any and all criminal proceedings hereafter brought against him in accordance with this agreement.
So on the state level, the cooperation agreements, like the federal proffer, that requires unequivocally that the client has to be truthful in that setting, correct?
Correct.
Let's talk about your representation of Mr. Troconis, okay? You indicated that in your earlier testimony on Monday that there were some material misrepresentations that you learned about that she had made, correct?
Yes.
One of them, for example, but not limited to, was the fact that she did a timeline indicating that she has showered with Mr. Dulos at 6:40 a.m. while she was in the residence at Fort Jefferson in Avon, correct?
Yeah, shortly after 6:40, because she said her alarm went off at 6:40.
And that was proven to be unequivocally not true. And you learned it was definitively not true when you looked at a warrant affidavit from September of 2019.
Correct.
And that there was no way she could have been showering with him at that time, notwithstanding her statements to the police on her first interview on June 2nd, 2019, and what she had reduced to writing in her timeline that she provided to you when she first met with you on May 29th, 2019.
That's correct.
And additionally, it's fair to say another material misrepresentation was that she indicated to the police on June 2nd, 2019, that she had seen Fotis Dulos in his office on May 24th, 2019, with Ken Mawini, an attorney, sometime between 8 and 8:15, and we know unequivocally that was not so.
That's correct.
Those are the same things she had told you in private early on, right? That she was showering with him and that Mawini was in the office with Fotis Dulos?
Right. She unequivocally told me that she showered with Fotis that morning and that she saw him in the office later that morning with Kent.
May I see counsel at the sidebar?
Yes.
You may proceed when you're ready.
And of course, on her timeline, she had omitted some material things as well, correct?
Yes.
One of them was the dumping of trash in various trash receptacles in the city of Hartford on the evening of May 24th, 2019.
The timeline ended at 5 p.m. There was no reference after that, including the trip to Starbucks that went through the north end of Hartford.
And there's no reference, for example, of her stating that Fotis Dulos had taken what appeared to be a FedEx folder out and dumping it into a sewer in Hartford.
No, there was nothing like that.
And there's no reference to the Tacoma in any of that timeline either, right?
Correct.
And your understanding is a Tacoma was driven by Fotis Dulos to drive from Fort Jefferson down to Jennifer Dulos' residence in the town of New Canaan.
That's what the evidence is.
And there's no reference also of her in Hartford where she stepped out of the vehicle, which was a Raptor, where she claimed to be wiping some gum off the sidewalk to clean her hands.
There was no reference to the trip to Hartford.
Do you recall in her interviews with the police, I'm referring now to the third interview, and for the record, this would be August 13th of 2019, which took place in Troop G in Bridgeport. Do you recall her stating initially that, withdrawn, do you recall there was questions asked of her regarding the cleaning of the Tacoma at a place called the Russell Speeder Car Wash in the town of Avon?
Yes.
And do you recall her initially telling the police that she had met Fotis Dulos at Russell Speeder?
She told the police that he went first, and then she received a call, I believe, from him, and then she met him at the car wash.
But later on in that same interview on August 13th, she then admitted she had actually followed him and they had gone to Russell Speeder's car wash in tandem, right?
Yeah, there was a video about it, or still photographs that showed her driving what she had rented, which was a Yukon, and it was really driving in tandem, follow him closely to the car wash when he was driving the Tacoma.
And that Tacoma was dropped off by Fotis Dulos so he can detail it not once, but twice. The same vehicle that was used to drive himself down to New Canaan on May 24, 2019.
Can I have the question again?
Yes, that Tacoma was detailed to your knowledge.
Yes.
Okay. And to your memory, was it detailed twice? In other words, that you paid for, the cleaning was paid for twice, that it was detailed twice by Russell Speeder?
I don't remember.
Okay. Do you recall her stating that, or the police mentioning that the detailing was paid for in cash and not a credit card?
Yes.
And do you recall Ms. Troconis telling the police that it was Fotis Dulos' habit while in the United States to pay by credit card and not cash? That was normally what he would do. Do you recall that at all?
You mean from the interview?
Yes.
I don't know if I remember it in exactly those terms, but there's no question he paid in cash.
Okay. And you recall the police telling her that, asking Ms. Troconis about why Photos Dulos would give her number to call when they were all done detailing the Tacoma,
Yes,
not Photos Dulos's, right?
correct.
The car wash, the detailing of the Tacoma, by coincidence, was the same day that you had first met Ms. Troconis.
That's correct.
And for the record, that would be May 29th, 2019,
Correct.
which was a Wednesday. Do you recall in your initial meeting with her on May 29th that she had told you whether or not she had dropped off a car, or whether Photos Dulos had dropped off that Tacoma at that car wash in Avon?
No, she did not.
That never came up.
It never.
And you indicated earlier in your testimony that when you first met her, she had come with Photos Dulos, but he was outside the door and the door was shut while you were just conversing with Ms. Troconis in your office.
He was out of range to hear what Mr. Troconis and I were discussing. He was not in the same room.
Now, let's get back to if there's a proffer agreement or a cooperation agreement, depending what agency you're with. Is it a federal agency or a state agency? But these were state charges. If you had entered into a cooperation agreement with these kind of material misrepresentations or lies, if you will, what would have happened to that agreement?
Well, first, there's no way that there would be a cooperation agreement with somebody being interviewed for the first time under these circumstances. But secondly, it would be null and void if you lie. And there was authority in the state of Connecticut that this was a consequential result of lying during a cooperation.
So there could be no cooperation agreement under these circumstances, all things considered.
Well, if there were, hypothetically,
Right.
okay, it would be void.
Why, under these circumstances, would there be no cooperation agreement? If you could just expand on that, please.
Because before law enforcement authorities, prosecution, let's just call them prosecution, before they enter into an agreement, a cooperation agreement with an individual where they're going to give them major concessions in their cases or in their potential cases, they're going to want to judge the credibility of the individual. So, I mean, it could happen, but generally speaking, the major considerations that a prospective defendant or a defendant would want would never be granted up front. It doesn't happen. They want to know if they can believe this person before they start making promises and giving them, protections such as use immunity, transactional immunity. There's a carrot and a stick here. And the carrot is, we'll go to bat for you. It could be the amelioration of the punishment. It could be dropping charges. It could be not bringing charges. But in return, you got to tell the truth.
Right. And she did not do so in this case, right?
No, she did not.
And she assured you that she would be truthful, right?
Yeah, she presented information to me as the truth.
So it's also fair to say when the prosecutor judges a potential witness in this circumstance, they're looking about what they said, how they say it, their demeanor, the inflection in the person's voice, things of that nature. Fair to say?
You're asking me?
They presumably they judge not just by what she says, but how they say it, the inflection of the voice, the demeanor, things of that nature.
Well, not only that, when they interrogate somebody in Ms. Troconis's position, they ask her questions that they believe they know the answer to, and other questions that they may not know the answer to. So they make a judgment about credibility in any person's case, judging by what they know with some certainty and how consistent the person is with what they already know.
And again, you testified earlier, it's your experience that the first time around they speak to a client, they don't tell them everything they know. You described it as a counterintuitive process. Do you recall that?
Yes, I do.
Okay. And that would be, so presumably subsequent interviews, presumably in your experience, the client would volunteer more information.
Happens a lot.
So it's fair to say the big problem in Ms. Troconis' case, to put it in simple terms, is that she wouldn't tell the truth on many aspects of the case.
The biggest problem was that she was untruthful about the biggest issue in the case.
Which was what?
Which was, where was Fotis Dulos on the morning of May 24th?
Of 2019.
Of 2019.
And you had reason to believe early on that if she did cooperate, she would not be charged with accessory to murder, right? She cooperated truthfully.
Well, that's what Mr. Colangelo had represented to me. But I was trying to keep her from being prosecuted, right through, further prosecuted or even prosecuted for the existing charges as late as August of 2019, as set forth in the letter that I wrote to Mr. Colangelo.
And you recall that during the course of these three interviews, on the dates of June 2nd, June 6th, August 13th, occasionally you would remind her and tell her, as a courtesy, to be truthful and tell them what you know, right?
Yes.
And obviously her credibility was impacted in part for the failure to reference or note the dumping of the trash in Hartford on the timeline and the trip to Starbucks after that.
It hurt.
What, in your estimation, hurt her credibility the most? Or was there one thing you could point to?
Your Honor, I interject because I don't know how that's relevant to.
I'm not sure that this witness can determine what's in the minds of the state representatives. I'll sustain the objection.
And you said you spent considerable time with her, prepping her, at least time is withdrawn. Time was of the essence on the first interview. Do you recall that?
Yes.
Okay. And you spent a certain period of time with her before she went in, and she did agree to speak to the police, and that was her decision, correct?
Yes. On my recommendation.
On your recommendation. But ultimately, that was her decision.
That is her decision.
Okay. And you did impress upon her in no uncertain terms that if you go in there, you have to be truthful.
Absolutely.
And in the subsequent interview, I'm talking about the one that took place in your office on June 6th of 2019. You had met with her for some considerable period of time before that second interview.
Yes.
In your office.
Yes.
And you had gone over with her, you anticipated what the questions might be that they may ask you. You discussed that with her.
We discussed obviously what they had questioned her about, which was a very broad interrogation. And we talked about everything that we thought would come up.
Okay. And again, you had no reason to believe at that juncture she would not be truthful in the second interview.
It was my hope and expectation that she would be truthful in the second interview.
And regarding the third and final interview on August 13th of that year, 2019, did you meet with her and discuss with her, again, what they may be asking her about on the third interview, meaning the police?
Yeah, specifically.
And you met with her for a considerable period of time, in your opinion?
Yes, it had been, more. It would have been from June 6 until August 13, as the time period in between the second and third interviews. And I had met with her frequently.
Now, so the last interview takes place on August 13th of 2019. And then did you write a letter to State's Attorney Colangelo later that month of August of 2019?
Yes.
And how did that come about?
Over that summer, I continuously spoke with and met with the state's attorney
Mr. Colangelo.
to attempt to convince him that she was not guilty of tampering because she didn't know what Photos was going to do. And she didn't know that whatever he was dumping, she didn't know was evidence of the murder. And I spent a great deal of time trying to convince him that she shouldn't not only be charged in addition, but that she wasn't guilty of the tampering or the hindering prosecution. And of course, the minute I concede that she could possibly be guilty of tampering, I mean, the mens rea for tampering and the mens rea for conspiracy to commit murder or accessory murder, that's a line that I don't go near. So it was always my position that she was innocent.
And you expressed that position to then State's Attorney Richard Colangelo.
Yes.
Now, I asked you earlier, in late August of 2019, you crafted a letter, and did you email that to State's Attorney Colangelo?
Yes.
Okay. I'd like to show you, for the record, what has been now a full exhibit, defendants or respondents exhibit E as in Edward. Can you take Attorney Bowman and look at this multi-page document, please?
Yes.
How do you recognize it, first of all?
Well, I wrote it. Okay. My signature's on the last page, my letterhead's on the first page, and it's accurate.
Okay. And that letter is addressed specifically to then State's Attorney Richard Colangelo, who was the State's Attorney for the Judicial District of Stamford at that time.
Yes.
What is the date of the letter?
August 27, 2019.
And how long is it?
It ends on page 7.
Is it single or double spaced?
It's single space.
Let's keep that up there for a moment. Was it your hope, among other things, to impress upon Attorney Colangelo why she might still be valuable as a cooperating witness in that letter?
Yes.
And did the letter also reference, among other things, that in your estimation, Dulos was a manipulator of Miss Troconis?
Yes.
And that would perhaps presumably account for some of her inconsistencies or omissions?
Correct.
And you also set forth in the letter the myriad of lies that you believe Dulos had told Michelle Troconis, right?
Yes.
And you do also emphasize in the letter that Dulos kept Michelle Troconis in the dark about so many things leading up to Jennifer's disappearance.
Yes.
And you also try to press upon Attorney Colangelo that, in your estimation, she was ignorant of what had happened in large part, that she was ignorant, Ms. Troconis, of many things. You tried to impress upon him about that?
Well, I mean, I don't use the word ignorant in the letter. I mean, I set forth in detail the best inference that could be drawn by her conduct, by what she said over time in the interviews, and that she was a very valuable witness for them. She destroyed his alibi.
And you emphasized that in the letter, among other things.
I did. Those were my words.
What did you try to convey or impress upon Attorney Colangelo about the timeline? In other words, did you try to assert that a photos Dulos had told her what to write down on those timelines?
I'm sorry.
Did you assert, among other things, in that letter that photos Dulos told her what to put down on the timeline?
Yeah, I mean, I was, I'm not going to bore you with the details of all the words of the letter, but it was the best version of what I believed one could reasonably draw at the end of the 3 interviews of her involvement, her knowledge, and what her value would be to the state in the prosecution of Fotis Dulos.
Okay. And did Attorney Colangelo, to the best of your recollection, ask for such a letter?
Yes.
So it's fair to say that you, as any good defense attorney would do, were still advocating on behalf of your client at that juncture.
Correct.
Let's have a moment, please, Your Honor.
Yes.
Can you explain for us why the unforeseen circumstance of Fotis Dulos' suicide in late January of 2020 was, in your words, devastating to Miss Troconis?
Quite simply because she had no one left to cooperate against.
And therefore she would have lost her leverage as a cooperating witness, so to speak.
Well, in her case, yes, but many cases across this country have people who are cooperators, and as a result of the cooperation, the principal pleads guilty. So there's no trial. But
Right.
Those cooperators get full credit for what they provided to the prosecution, theoretically and actually, because it led to the principal's guilty plea. But in this case, because they had such doubts about her credibility, Dulos' death was just devastating.
Oh, another moment, please.
Yes.
I'm just looking for my notepad, just so you know.
Right.
Your Honor, at this point, I have concluded my cross-examination.
Right.
I would ask this court, not again, but this is my first time requesting it, to reserve the right to recall Attorney Bowman if I deem it appropriate during the respondent's or defendant's case in chief.
Is he on your witness list?
He is.
That's
you.
noted. Redirect when you're ready, Mr. Brown.
Just as the comment on that, it was my understanding that there was going to be no scope objections because of the returning witness. If it comes up, we can discuss it then. I just want to say that was my understanding, and that maybe it hopefully won't be an issue at all.
I hope not as well.
So I may stay over here for this time. Attorney Bowman, good to see you again. Let's just start with the letter that talked about from, it would be Exhibit T, the response Exhibit T. When was that letter from?
Could you be a little more descriptive? So I don't know what Exhibit D is.
Oh, sorry. The letter from your office that was shown today from the federal
Rich
judge.
Kaufman?
Yes.
Yeah.
Do you know when that was from? I can show it to you if you need it.
He was the chief judge of the United States Court of Appeals for the Second Circuit.
The letter's from December 1979.
Yeah.
When did you represent Ms. Troconis?
Not then. I represented her in 2019.
And I know you're not. Let's just say this. You understand that we could all agree you're a great, experienced, distinguished lawyer. There could still be a breakdown in an individual representation. Would you agree with that?
Objection argumentative.
I'll allow it. Go ahead.
Hypothetically?
Yes.
Hypothetically, sure.
Okay. And we're just talking about 3 interviews that Ms. Troconis did in 2019 while you represented her.
Oh,
right?
I understand that.
Yes. And so you went through the different types of protections that are, well, you're asked some questions about proffer agreements, cooperation agreements, things of that nature. Is there a cooperation agreement or a proffer agreement, whatever you call it, that's sort of a contract between the attorney for the state and the attorney for the defendant, correct?
It's a contract between the prosecution and the defendant or the person being interviewed, not the lawyer.
I guess my question is the actual terms that are in there. There can be, and there sometimes is, discussion of what the terms will be. Would you agree with that?
It depends. There are terms that are not negotiable.
Okay. And I don't know what your position is today, but I understood your position on Monday to be that you never thought that Michelle was purposely lying to the police. Is that correct or is that not correct?
Objection. I think that mischaracterizes the testimony.
I'll allow it. The answer.
I didn't think she was purposely lying to the police on June 2nd. On June 6th, she, as I recall it, and I deferred to the actual video, when they were talking about Fotis not being home on the morning of the murder, she said to Kimball, I believe, if you say he was home, he was home.
So even taking that, for example, a lie that would make up a charge of, say, perjury requires knowing misinformation. Would you agree with that?
Objection. There's no indication that the defendant was under oath to give rise to such a charge.
I can try again.
Fair point.
Would you please restate?
Yes,
I'll sustain the
yes,
objection.
I'll start over again. Whether it's a legal term or not, lie means something we can agree is fairly specific.
Yes.
Does a lie, to say that someone's lying, does that usually suggest that they know they are telling something untrue?
Yes.
So you would agree that there could be an untruth said that is not necessarily a lie under our kind of sort of shared understanding?
You could have something that is, somebody says that's untrue, but not necessarily because they're lying.
Okay. Would you agree as far as where Fotis Dulos was that morning, May 24th, 2019? There's sort of two separate questions. One is where he actually was and where Michelle knew him to be. Are those two different questions?
Yes.
Okay. And you said that you came to discover or believe that it was unequivocally not true that Fotis took a shower with Michelle that morning.
Correct.
And that, did you say that it was unequivocally untrue based upon what you read in a warrant?
Correct.
And did you have access to evidence about sort of the pieces that made up that belief that the state had?
Yes.
And I guess I could go through it, but do you remember what that evidence was?
Well, the evidence was a photograph.
Okay. And were there clips from different parts of the highway?
Yeah, the rest areas in Fairfield and New Canaan, the school bus video in New Canaan, and other photographs. Yes. Clips.
I don't mean to go far down this road, but did that evidence show beyond a shadow of a doubt that Fotis Dulos was driving that Tacoma that day?
To me, yes.
Okay. And that's based on your judgment by looking at the evidence that was presented?
And everything that I knew about the case.
Okay. And even if beyond a shadow of doubt, you believe that Fotis Dulos was driving that car that day, that still doesn't address the second question. Would you agree?
Objection to the form of the question.
I'm just not sure what you mean by the second question.
The second question I just set up with what Michelle Troconis knew about what Fotis Dulos did that day.
I'll allow it.
Okay. If you're asking me, did I believe that she knew what he was doing? Is that what you're asking me?
Or even that he couldn't have been in the house that morning.
I'm going to object. It calls for, it's almost the equivalent of a compound question.
I don't think so. Overruled.
Okay. Let me make sure I understand. Yeah. All right. You're asking me if she could have misremembered rather than intentionally lied about Fotis Dulos being with her that morning.
Yes, I'm only asking about possibilities.
And I'm going to object that it calls for speculation.
Anything's possible. You'll have to be more specific.
Okay, so I guess I'll just ask you based on your cross-examination. You said you found unequivocal information that Fotis was not in the house that morning. is that unequivocal information that Michelle Troconis lied to the police about her knowledge of where Fotis Dulos was that morning?
It was the consistency of what she was saying that I'll call a lie. I don't want to be pejorative about it, but that's what it appeared to be, because she was clear that she saw him twice that morning. You know, once when she took a shower with him, and once when she came back from dropping off her daughter at the Ethel Walker School and saw him and Kent in the office.
Was there a later explanation that she made during the interviews about why she thought Fotis was in the office that day?
Well, she said in part of the interview that she assumed that he was. I mean, there was a certain assumption that she had used as a characterization, but not. The problem was that after, it was toward the end of the initial interview on the second, where, you know, now she's being much more definitive.
And just, if you remember, what were some of those bases for the assumption about him being there for the second time that day with Kent in the meeting?
You mean the telephone? You're talking about the phone? I mean, listen. I'm not trying to avoid your question. I don't understand what you're
asking. I'm not to lead
asking.
you too much, so I'm just saying: how would the telephone be part of that issue of the assumption that she could have made?
His telephone.
Well, what about the fact that Kent was there at all? Did she say that was part of her assumption of why Fotis would also be there?
I think there may have been a time where she said she saw Kent and assumed Fotis was there, but there were a number of different versions. But in the end of that interview, she was definitive about the fact that she took a shower with Fotis and that she was in the office, or she went into the office or saw Fotis and Kent in the office together at the same time.
You sure in the second interview that she said that she saw Fotis with her own eyes with Kent in the office?
Say it again.
It's your recollection.
This is the first interview.
Oh, first interview. Okay. And I'm just asking if you agree with me that at some point she says it's a big house. Kent wouldn't be there if he wasn't meeting with Fotis. It's a big office. I didn't actually see them. There was some reasoning of why she had assumed that without actually seeing Fotis. Is that true?
You know, I'm going to object as leading.
Well,
If you don't have a legal basis for the objection, please don't make it.
Leading.
What's the legal basis?
It suggests the answer.
I'm allowing leading questions because the witness is adverse. Overruled. You should answer.
Yeah, I understand. She said that at some point in the interviews. Yeah.
I guess I'm just asking, she had some things that she was saying, whether the police or anybody else accepted them, about why she would have believed that Fotis was in the house, even if he wasn't. Is that fair to say or not?
I'm not challenging what she said. I remember, her saying that.
And do you remember there being, well, and this issue of whether she was remembering incorrectly or lying or what the reasoning was, did you ever do anything to explore that issue beyond just talking to Michelle, or attempt to do that?
Object to the form. What specifically?
Well, I'm trying not to lead now, so I don't know which one to...
All right, if you understand it, please answer.
Yes. You're asking me, did I ever do anything other than speaking with her, looking at the evidence to determine whether she was lying or not? Yes.
Okay. And do you remember any examples or?
Well, I can give you one. On the day of her arrest for conspiracy to commit murder, she was at a neuropsychologist's office, and I had sent her there to be evaluated because I wanted to know why she was so sure about something that she was so wrong about.
And did that evaluation ever get finished?
Well, that day it was preceded by Richard Colangelo calling me. I was in New Haven, telling me that they had a warrant for her arrest for conspiracy to commit murder. The doctor's office was on Main Street in West Hartford. And I said, I know where she is. And of course, they knew the general area where she was because she had a bracelet on. So I was driving up 91 and I said, I won't tell you where she is until I'm there. And so that's exactly what happened. I called the psychologist who I had never met, but just hired, and told him about it. And I said, I want to make sure she's okay. And she got on the phone and I explained to her what it was and that I was coming. And I held the police off until I got there. And they couldn't pinpoint the place, for everybody who wants to know if the police really can follow you if you have a bracelet on. So I got there. I told the police where we were. They came in and they arrested her.
Do you remember the name of the psychologist?
Peer. P-I-E-R.
James Peer?
Correct.
Do you recall if you had any other accommodations for that evaluation set up for her?
Any other
accommodations
set up for her?
Yes, for that interview or for that evaluation.
I don't understand what you mean by
Spanish speaking accommodation.
I don't remember.
Would it refresh your recollection to look at a document related to that?
Sure.
Just one more. I wasn't sure we were going to go this far. Oh. Just a reflection. Just review. Dan, tell me to refresh your recollection on the issue of the Spanish-speaking accommodation.
I know. Okay.
Have you looked at it?
Yeah.
Can I take it back from you?
Of course. Yeah, I just saw the third page, which I don't know had anything to do with it, but.
Does it refresh your recollection of whether there was going to be a Spanish-speaking part of that evaluation?
Yeah, I think I told him that she had spent most of her life in Latin America, and then, if they had anybody there who spoke Spanish.
And so did you have any exact prior diagnosis or anything about Michelle to make you do that evaluation that was scheduled?
Did I see a prior diagnosis?
Yes.
No.
So is it fair to say you were sort of exploring this answer to the question that you had about the interviews?
Yeah. Certainly.
Is it fair to say you weren't convinced that she was just outright lying at any time that you represented her? Is that fair to say?
No, it was, I'm her lawyer and I have to explore that possibility.
Okay. And I'll ask you this way. If she said to you in a meeting, I'm lying about this whole thing, would you have gotten the evaluator to explore her memory issues?
You mean if she had just said, I'm lying, there could be other problems there. Okay. I
guess I'm just saying there was some reason to explore it, that it wasn't a closed issue to you, at least at that time.
Nothing was a closed issue for me. Okay. I was a lawyer.
Yes.
She was facing serious, charges.
And to jump around a little bit, the timeline. It didn't include Albany Avenue and all those things, right?
It included, I'm sorry?
It did include the trip to Albany Avenue It
ended at 5:00, right?
Okay, and that's the thing about ending at 5:00. So if, for example, Michelle cooked dinner for her daughter, that wasn't in the, right?
It ended at 5:00.
Okay. And do you know whether she was told to do the daytime or 24 hours or what the sort of mission was at the time that timeline was put together?
It was my understanding that Fotis and Mr. Troconis and Pavel were present, I think, in the kitchen at Fort Jefferson when it was done. And from what I understood, Fotis took the lead in talking about what should be on the timeline.
I mean, as far as saying what happened that morning, that day, you don't know how broad even from the lawyer saying that you should do a timeline, what the time frame was, or do you know what the time frame was that the lawyer asked for?
I don't know what the time frame was that the lawyer asked for.
So I know I'm jumping a little bit, but you said that about getting protection for a first interview would be impossible. Is that what I understood your testimony to be?
I'm going to object that
I never-
mischaracterizes the
The witness can answer rather than counsel.
I never used the word impossible. I never used that word.
Okay. Would it be impossible to get protection for a first interview under any circumstances?
Hypothetically,
Yes.
yes. Happens,
It could happen?
it happens.
Okay. But it was never discussed in this case, right?
There was a time imperative, and I made a judgment. And I had a client who was very persuasive about her innocence and her credibility.
Going to the different protections, you were shown examples of a cooperation agreement, proffer agreement, and all those things. Can someone be charged with making a false statement to the police without a cooperation agreement in place?
Of course.
And can they be charged with making a false statement without a proffer agreement in place?
Yeah, there are statutes about that.
How many warrants came down while you represented Ms. Troconis?
How many?
Warrants?
Too many.
Okay.
There was June 1st, tampering and hindering. September 3rd, which was tampering. That was the Russell speeder. And then January 6th, the conspiracy to commit murder. 3.
At any time that you represented Michelle Troconis, was she charged with making a false statement during any of those interviews?
She was not charged.
Okay.
Mr. Brown, just tell us, we do need to take our morning break. Tell us what an appropriate time is.
It's perfectly fine time.
Good as any?
Yes.
All right. Stand in recess for 15 minutes. When you're ready, Mr. Brown.
Thank you, Your Honor. So I want to just go through quickly the second interview and the third interview, a few things about sort of this idea of lying and the things that you had been given from the police and then what was said in the interview. Is there a point early in the second interview where it became clear the police still didn't think Michelle was telling the truth?
Yes,
Why didn't you cut off the interview when that became clear?
because she was making progress.
How so?
By the virtue of what she had told me before we went in. And I didn't think that stopping the interview while the police thought she was lying was a good thing to do. The last impression that she leaves as a liar, I thought that was against her interest.
And just going back before the second interview, you said based on things that she had told you, are there things that she told you before the second interview that she held back in the actual interview, or can you explain that for me?
I understand your question. Were there things she told me that she held back? I mean, there could have been things that she wasn't asked, but she was consistent.
And I guess I'm saying there was not a checklist of things that you were planning to give to them that could change their position in the case, that Michelle didn't perform the way she had specifically told you she would before.
You mean a theoretical checklist?
I'm asking if there's a plan to give them something in the second interview that Michelle then didn't give to them when the interview started.
Okay. For example, where were you? Where was Fotis Friday morning? They wanted to know what she knew when they were driving in Hartford. It could have been first and second. All right. And she was consistent. And I thought she was making progress. They thought she was making progress. And I saw no reason to terminate the interview.
So with the making progress and also the advice that you gave before any of the interview started, is there some tension between this idea that you have to tell the truth? That's the only advice the predominance of the advice about tell the truth at all costs versus the counterintuitive gradual process that you've also described. Is there a tension between those two?
Of course.
Okay. What did you tell her about that?
She had to tell the truth.
Okay. But you also say it's this gradual counterintuitive process. I'm just not, I don't know that it's clear.
Because in my view, at the time and throughout, she was afraid that if she told them everything she knew, that she would just put herself in further and further jeopardy.
Okay.
That's the impression that I got.
And as far as a proffer agreement or a cooperation agreement, we already talked about how it doesn't protect against lies, but would you agree that it protects against those types of things, of these sort of details that could show your involvement, but...
The problem was she became definitive about where he was. And that happened at the end of the first interview, where she said she gave the time when she got up at 6:40. She went in, turned off the alarm in their bedroom. Okay, she's sleeping in Nicole's bedroom. She goes into their bedroom, turns off the alarm, goes in the shower. Fotis jumps in the shower with her. She goes down and makes breakfast, takes care of Nicole, she goes to school. She comes back, and at 8:20, she's definitive that she's back at the house, and she sees Fotis and Kent in the office.
And so in the second and third interview, even then, well, with John. So for the third interview, same sort of premise that I was at the second interview. Was there a time when that interview started that it became clear the police still did not think that she was telling the truth?
In the third interview?
Yes.
Well, when I wrote the letter 2 weeks later, I said in the letter that I thought she did well, that I thought she destroys his alibi now. She was saying that she wasn't truthful and that Fotis was in the house. But it was a process. So, in the second interview, she said, well, if you say he was there, then he was there. That was like, okay, I hear you. And if that's what you want to hear, that's what I'm going to tell you. So that's not a full recantation of what she said before. But by the time and that's why I wanted her to do the third interview.
And when you wrote the letter to Attorney Colangelo, I think on Monday we talked about sort of the relationship that you had with him to some degree before that. Is that you had that good relationship you talked about?
We had a respectful, professional relationship. When you say it was good, I thought it had always been honest and productive.
And as far as the honest part, was that like a two-way street between you and Attorney Colangelo?
Well, when I say honest, what I choose to tell a prosecutor, I want to be pretty sure that what I'm saying is so. And if I can't say something honestly that is going to hurt my client, I don't say it.
But you did write that letter?
Yeah, I wrote it. Yeah.
And you didn't say that Mr. Troconis had lied at any point in that letter?
What I said in that letter was that as of the third interview, she destroys his alibi.
Do you think that letter is a fair representation of your thinking about the case at that time?
Objection relevance.
I'll allow it.
It was a letter that I think represented the best objective inferences that could fairly be drawn in Michelle's favor. My opinion is really not, I'm writing a document that I want him to take seriously, and because of that, I have to rely on objective reality.
So it's the best version of events based on truthful things that you can put into
Yeah.
writing?
Yeah.
Okay. And this idea of no one being left to cooperate after Mr. Dulos killed himself. And you talked about when people plead guilty that people get full credit for cooperation.
Yes.
Did you have anything in place with the state at the time of the suicide that would have ensured her full credit if Mr. Dulos had, say, confessed and pled guilty instead of killing himself?
No.
Okay. And would you agree that while suicide is not a likely scenario, someone themselves admitting guilt and pleading guilty is something that could happen reasonably foreseeable in a situation like that?
Sure.
Okay. And there was no protection for Michelle if that happened. Is that fair to say?
You mean as of January?
Yes.
I think that when they got the third warrant for conspiracy to commit murder, that was their position with respect to whether they believed her or didn't believe her.
Just a few more questions. Do you recall when you actually got what you would call the discovery in this case? Like where along the process you were?
Well, we had gotten things like the DNA on the tie from 80 Mountain and what they retrieved from the receptacle in Hartford. The C4 surveillance in Hartford. Gotten a bunch of exhibits, a lot, pages and pages of tangible evidence that they had.
Are you able to play, if you are at all able to place where in the timeline of events you got what could be called the discovery package or these materials?
I was rolling.
Okay.
No, I mean, I can't tell you this minute, but, as I got it, she would come to the office and we would go through it with her.
And you sent the bill to Ms. Troconis, correct?
Yes. Well, no. I sent, after they hired new counsel, I gave them a statement of all the time spent. Yes.
Would it be your practice to review discovery when you received it in most cases? Close in time?
Would it be my practice to
Review the discovery
review
close in time after you receive it?
Yeah.
Okay, so if to the extent that that bill talks about, or that accounting talks about discovery review, that's probably coincides with when you receive discovery?
Yeah.
Okay.
I believe it would.
Okay. Nothing further, Your Honor. Thank you.
Any recross?
Yes, please, Your Honor.
Go ahead.
It's fair to say that one of the purposes of the second interview was in a way to sort of rehabilitate her credit.
Correct.
Same with the third.
Yes.
And you said that you thought you were of the opinion that, at least in the second interview, you were making progress.
Yes.
It's fair to say in that letter that you authored and sent to Attorney Colangelo dated August 27th of 2019, you were obviously advocating for a client at that point.
Of course I was.
And that you indicated that when you received the evidence, you would have Ms. Troconis come to your office and share with her the evidence or the documents you had received as part and parcel of the discovery process.
Yes.
And the DNA report that you referenced in your redirect examination, one of those reports noted that her DNA was on, meaning Ms. Troconis' DNA was on the outside of one of those bags.
Yes.
You mentioned about a proper agreement and the cooperation agreement on your redirect. The terms that are not negotiable are the consequences which flow from lying or misleading. Fair enough?
The non-negotiable term is that you have to be truthful.
And Ms. Troconis later admitted on the third interview, the August 13th interview, that she was not in the shower with Photos Dulos at 6:40, as she indicated in the very first interview, right?
Correct.
And she finally acknowledged that, right?
Correct. And
She also acknowledged on the third interview that she never did see Photos Dulos in the office with Ken Mawini, right?
yes.
on the morning again of May 24th, 2019.
Yes.
And again, jumping back, on the end of the first interview, the June 2nd interview, she was more definitive at that time of saying she did take a shower with him at 6:40, right? Or he joined her in the shower.
She was definitive.
As well as she was definitive also about, on the June 2nd interview, as it went on, later on, about seeing Fotis Dulos and Ken Mawini in the office on the morning of May 24, 2019.
Yeah, those questions at the end of that interview were in close proximity to each other, and she was definitive on each.
The investigator that you hired, Attorney Bowman, what was his name?
Dan Markle.
And had you worked with Dan Markle previously?
Yes.
And how long had you known Dan Markle at that time?
Probably 10 years.
And it's fair to say you were certainly satisfied with his services?
Yes.
What was the purpose of that evaluation that she was undergoing in January of 2020?
Well, I had gotten the referral from a neuropsychologist at Yale who I had hired previously in cases, and for one reason or another, they couldn't do it. And she referred me to Dr. Peer, who I had no knowledge of before.
Okay.
But I trusted her.
And what was the intended purpose of that evaluation, if you recall?
To see whether she had any cognitive or other deficit that could account for her definitively saying that Fotis was Uncle Jefferson on the morning of May 24th.
And you said regarding that timeline that she provided to you when you first submitted her again on May 29th of 2019, it stops, you said, at around 5:10, the last entry?
Yes.
Okay. Doesn't mention again anything involving the dumping of the trash in Hartford that evening.
Correct.
Okay. But she does, however, mention that at 8:30 that morning, she made an omelet for herself.
Yes.
That's it. Nothing further.
Right, Mr. Bowman, just one question. You referred to something as the pond. What is that?
It is actually a pond. It's not far from Fort Jefferson, and it's a place where they went water skiing.
Okay. In Farmington.
I'm not sure, Your Honor, if it was Farmington or Canton or Avon. It's in that area, but it certainly was a recreational area that they used.
Thank you, sir. If you're excused, you may step in. Next witness, when you're ready. If it makes sense to start.
I think we might start with Attorney Colangelo, and I'd like to retrieve him from the hallway.
Yes. Good afternoon, sir. You remain standing and face the clerk.
With your right hand, do you solemnly swear or solemnly sincerely affirm that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth? Will help you God or upon penalty of perjury.
I do.
Please state your name, spell your last name, and give your business address.
Your Honor, if I have to give my home address? Or...
Yes, whichever you prefer, sir.
Okay.
You don't have
We just do city of residence, city or town?
city is fine.
Thank you, Your Honor. Richard Colangelo, Colangelo, Easton, Connecticut.
When you're ready, Mr. Brown.
Yeah, so, one moment. Good afternoon, Attorney Colangelo. In May of 2019, what was your employment?
I was a state's attorney for the Judicial District of Stamford, Norwalk.
And did you at some point become involved, or, well, we'll start with aware of the disappearance of Jennifer Dulos?
Yes, I got a call the night that she disappeared from the New Canaan Police Department and was involved in the investigation from that time forward.
When you say involvement, can you just describe a little bit what that meant in this case?
I worked with the police. I reviewed their search warrants. We met on strategy.
And do you remember when if you remember, when you first became aware of Fotis Dulos as a suspect in the case?
He came down to the New Canaan police the day after, I believe, Jennifer went missing. We seized his phone, got a search warrant, searched it, and then that led us to Albany Avenue in Hartford.
And Albany Avenue is where the video through C4 was found of
Mr. Dulos, yeah, there was video from C4 and some of the, like a bodega, a couple of companies that showed the Ford Raptor stopping and Mr. Dulos dumping things in dumpsters or trash receptacles.
And when did you become aware of Michelle Troconis in that period of time? If you remember.
During that same period of time, because she was seen in the video, she was in the truck and she seemed to hand him something at one of the stops, one of the videos. And they had gone to, tracking his phone, they had gone to Starbucks. So she was in a video at Starbucks with him that same night.
And the disappearance got a lot of media attention from the beginning, would you say?
You could say that, yes, sir.
And the police, the state, there's a lot of pressure to find Jennifer, would you say?
Yeah, I think the pressure was probably self-imposed. We had a mother of 5 missing. That was our goal.
Thanks. And quite a few resources were going into the investigation, trying to find Jennifer.
At one point in time, we had every state police major crime unit, every K-9 the state police had, New Canaan police. Yeah, there was a lot going into it. Yes, sir.
And do you recall when Ms. Troconis when an arrest warrant was first obtained for her arrest?
Beginning of June.
Okay. And do you remember what the conduct was that made up that arrest?
For the dumping of the items along Albany Avenue, we got DNA results back. There were items in those bags that we recovered that had Jennifer's DNA on them.
How did that become a Stamford case? Do you remember?
She was missing it from New Canaan.
Okay. And eventually, Mr. Troconis and Mr. Dulos were arrested for that first warrant?
Beginning of June, I'm not, don't ask me the exact date because I couldn't tell you, but yes.
Do you recall finding out that they had actually been arrested, the warrants had been served?
Yes, I got a call that they gotten arrested. And I think at that time I was told that Mr. Troconis was going to be represented by Attorney Bowman.
Okay. Is that at the time of the arrest that you found that out?
Yes.
Okay. Do you remember kind of who you would have, sort of the sequence of events to find that out, to the best of your recollection?
State police, I believe it was Sergeant Ventresca. He was kind of running the investigation, state police, New Canaan. So I believe it was him that called me and said that Attorney Bowman was going to represent her.
Okay. And that's, you believe that even like close in time to the arrest or not?
Yes.
The following one? Okay. Do you know why Ventresca would have called you to tell you that she was represented?
We wanted to try and get her to cooperate.
Okay. And then did you find out that Attorney Bowman had actually come to see her at some point?
I did. I was called when he was leaving the department without her talking to us. And I gave him a call. I gave him a call actually when I found that out.
And did you catch up with him at that point?
I did.
Okay. And would it be fair to say that's probably June 2nd, 2019, the Sunday when she was in custody of the New Canaan Police Department?
If that is the date, yes, sir.
Okay. And what do you recall about that phone call with Attorney Bowman?
I got a hold of him. I said that, we really want to hear what she has to say. We'd like her to cooperate. I remember saying that now's her time to either get on the bus or get run over by the bus. She really should talk to us and tell us the truth.
Did you tell her anything? Did you tell Andrew Bowman anything about what would happen if the body was found and what charges Mr. Troconis would face, if you recall?
I'm sure that I said that if we find her, she'll be arrested as an accessory.
Okay. Do you know if you said accessory to murder, or was that implied, or was that direct, or if you recall?
Yeah, I probably said murder.
Okay.
Based on the evidence at the scene, we were under the assumption that Jennifer wasn't alive.
And that's evidence from the scene of Jennifer's home?
Yes, sir.
And based on your testimony, is my understanding correct that the substance is, or the idea is that she should talk before the body was found?
Yes.
And that would be to her best benefit.
Yes, sir.
And if she didn't cooperate and the body was found, then there would be that charge described.
Yes.
Did Attorney Bowman, I'll say, push back with any of that?
He said he talked to her.
Okay.
My recollection is he said he talked to her.
Okay. And it was your belief at that time that she'd, in fact, Jennifer had, in fact, been murdered and was dead?
We were operating under that assumption, yes.
Did you have any, did Attorney Bowman ask you what the idea of a charge of accessory to murder would be based on at that point?
I don't remember us talking about that. It did come up after that, but not in that initial conversation.
And the best your ability to kind of go back to that conversation.
Yeah.
Do you know if you were asked what your basis of saying that Michelle Troconis was responsible for being accessory to murder was at that point, what you had known at that time?
She was with him while he was dumping the items along Albany Avenue. If you looked at that video from Starbucks, she was obviously nervous in that video. And there was no sound, but just looking at body language, he was trying to calm her down. And she was obviously distressed or nervous in that video.
So it's the video at that point? Is that fair to say? In that conversation, at least, the video is the basis for your intention?
For my thinking, yes.
Yes. Okay. And fair to say you couldn't charge anyone with the murder at that point because you didn't.
Correct.
What had happened? Okay. Was there any discussion of, I'll say it broadly first, protecting Michelle during that interview that was raised to you by Attorney Bowman?
No, not that I recall.
And just generally speaking, were there any practices or policies that were, whether they're actual set policies, but was there anything in place that someone could get protection at your discretion in a situation like that?
Several different, yeah. I mean, immunity, proffer agreement. I would never do something like that without knowing what someone was going to say, though. And so it never came up, or it never was part of my thinking at that time.
And have you ever had the experience where an attorney presents a proffer to you of this is what my client will say if they talk, as a conversation piece to deciding whether you want someone as a cooperator?
Sorry, yes, that's happened, but I usually like to have it. I'm not very trusting. I'm not a very trusting individual, I would say. So lawyer saying it doesn't mean much to me. It would have to come from the client.
Fair to say that none of that was even discussed or broached in any of the conversation before the first interview of Mr. Troconis?
No, so it was a quick phone call.
And that sort of attorney-led proffer or attorney-extended proffer that I just discussed, could that in some circumstances be the first step towards setting up the discussion with the potential witness directly?
Sure.
And fair to say, as the state's attorney in the district at that time, you would have had you'd have authority and discretion to decide how to work with somebody in a cooperation situation?
Yes, sir.
Okay. And I understand that the conversation was set up as if the body's found, there'll be a future charge, but would you say that you believe that Michelle was potentially valuable to the state's investigation at that point?
Objection, Your Honor. It's getting into the thoughts or opinions of a state's attorney. I would cite practice book section 40-14, subsection 3, where the records, correspondence, reports, or memoranda to the extent that they contain the opinions, theories, conclusions of a prosecuting authority are not subject to disclosure.
Disclosure.
All right. I'll take a look at this at lunch.
Perfect.
Standard.
Oh,
Go ahead, Mr. Colangelo.
I might be able to answer it without my belief.
Would that be acceptable?
Yeah, that would
All
be.
right, thank you, sir.
It was always my idea up until the time that Mr. Dulos passed away. I was trying to figure out a way to use her as a witness against him.
Okay. I don't have anything further. I don't know if that helps at all with the lunch situation, but that finishes my direct.
All right,
So
well, that's convenient.
Yeah.
We'll hear cross-examination after lunch.
Yes, Your Honor.
Stand in recess until 2. Colangelo. Good afternoon, sir. Please have a seat.
Thank you, Your Honor.
You've finished direct examination, Mr. Brown.
yes, Your Honor.
Cross-examination when you're
Yes, I won't be very long, Your Honor. Attorney Colangelo, fair to say you had known Attorney Bowman for many years prior to this incident.
Yes. Yes, sorry.
Yes. And you had many cases with him,
We had cases over the years, yes, sir.
both when you were an assistant state's attorney as well as the state's attorney for the JD of Stamford.
Probably starting when I was a deputy assistant in Norwalk and up to assistant, senior assistant, and state's attorney, correct?
It's fair to say that you had a great deal of respect for him in your dealings with him,
Yes.
and you found him to be above board and honest.
Yes.
It was a relationship that was a professional one based on mutual respect and trust.
Yes.
And lastly, did you ever tell Attorney Bowman that if Ms. Troconis did not speak with the police about Jennifer's disappearance, she would be charged with accessory to murder and that she would never see her child again?
I never said anything about her child, no.
Okay, thank you. Nothing further.
Redirect when you're ready. Yes.
Nothing further. Thank you.
Thank you very much. Your Honor, Colangelo, you're excused. You may step down. Your next witness when you're ready, Mr. Brown.
Attorney Michael Fitzpatrick, please.
Good afternoon, Counselor.
Good afternoon, Your Honor.
Please remain standing and face the clerk if you would.
Please raise your right hand. Do you solemnly swear or solemnly sincerely affirm that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury?
I do.
Please state your name, spell your last name, and give your business address for the court.
Michael Fitzpatrick, Fitzpatrick, 10 Middle Street, Bridgeport, 06604.
Please have a seat, sir, and keep your voice up and answer the question.
Yes, Your Honor.
When you're ready, Mr. Brown.
Can I just have one moment? Your Honor, I readjusted my papers before lunch, and I just need to reconstruct all my things. Good afternoon, Attorney Fitzpatrick.
Good afternoon.
Tell us a little about your practice, your background.
Sure.
For individual things, but start with an overview.
I've been practicing law since 1987. I'm admitted in Connecticut, also the Federal District Court, the Second Circuit, and the United States Supreme Court. My office is in Bridgeport, but my practice is statewide. My practice consists of criminal defense and civil litigation. About 95% of the practice is criminal defense. And with regard to criminal defense, that includes trials, appeals, and other forms of post-conviction relief.
And just following up with that, how many jury trials do you think criminal jury trials in Connecticut have you been a part of?
To conclusion, 33.
And have you tried murder cases before?
I believe 16.
Okay. And backing up just a tiny bit, can you tell me about your education? I don't think you told us in that initial round. Where'd you go to school?
I'm a graduate of Purdue University. I went to law school at the University of Bridgeport when they had the law school. Subsequently, it became Quinnipiac University School of Law.
Have you handled criminal cases in Connecticut dealing with cooperating witnesses?
Yes.
Have you represented cooperating witnesses?
Yes.
Have you handled cases where you've entered into cooperation agreements?
Yes.
Have you been in cases where there have been proffer agreements involved?
Yes.
And are you familiar with Attorney Colangelo?
Yes.
Have you had cases with him?
The answer is yes.
Okay. And what about Attorney Andrew Bowman? Do you know him?
I've known Attorney Bowman since I've been practicing, so 38 years.
Okay. And did you talk to him about this case?
No.
Did I ask you, or was your mission to talk to him about this case?
I'm sorry, say that again?
Did I ask you to talk to him about this case?
No.
Okay. And have you ever been in a position to give a public compliment to Attorney Bowman?
Yes, quite some time ago, 15 to 20 years ago, I paid him a compliment.
And was that in a public place or privately or?
Well, It was in the case of United States versus Giordano. I felt that he was being unfairly criticized. A newspaper reporter called me, and I defended him in the press.
And as far as your involvement in this case, you were retained as an expert in this habeas corpus proceeding?
That's correct.
When was that?
The official date was November 21st, 2025.
And were you familiar with this case before November of 2025?
Yes, I was.
Can you tell me how you were familiar?
I had been retained as the expert in connection with the suppression hearing at the original trial. The attorney that retained me was Attorney John Schoenhorn.
Did you ultimately testify in that trial?
I did not.
Did you provide some information or opinions to Attorney Schoenhorn at least?
Yes.
Okay. And did you review materials that were available at that time for Attorney Schoenhorn?
Yes, I did.
And did you have a draft opinion at that time that you rendered to Attorney Schoenhorn?
Well, I had an opinion.
Okay. And then, have you ever testified as an expert before?
Yes, in my career, I've testified approximately 12 times as an expert, either in habeas corpus proceedings or in civil actions.
Okay. And specifically in habeas corpus, do you have a number of how many times you've testified?
Approximately 12 times.
Okay. And are you able to separate out the civil non-habeas or?
Sure. I think one of the 12 involved legal malpractice between private parties. So the other 11 were habeas corpus cases.
Was the habeas corpus of Michael Skakel one of the habeas cases that you testified in?
Yes, I was the legal expert in the Skakel habeas.
Okay. And you said you testified 12 times. Is that the sum total of the times that you've been consulted with or asked to potentially be an expert?
Well, let me revise that. Out of the 12 times, perhaps I haven't given testimony in every single one of those cases. There could be one or two cases where I was the expert, but for one reason or another, it did not become necessary to call me as a witness.
Are there other cases where you've been asked to be an expert, but you've declined to give a helpful opinion or any opinion at all?
Many.
Okay. Can you tell me a little about how that process would work or a little more about that?
Since the Skakel case, I get a lot of requests to serve as an expert with regard to ineffective assistance of counsel. I probably get at least 6 to 8 requests a year. And, I field the requests as they come in.
Are there some times that you might know the attorney or the case that it is and say, this is not maybe the right fit right now to work on that case? Has that ever happened?
I turn most of the cases down.
Okay. Do you ever look at a case and say, I'm not able to help you with a helpful opinion?
Yes.
Objection on leading.
Technically it was. I'll let the answer stand.
Okay. And if you're being compensated for this case?
Yes.
Can you tell us about that?
I'm being compensated at a rate of $350 an hour.
Okay. And were you also compensated for your participation in the motion to suppress part of the case?
Yes.
Okay. Are you familiar with the standard of care for criminal defense attorneys in Connecticut in 2019?
Yes.
Did I ask you to render some opinions about the performance of Attorney Andrew Bowman during May, June, July, and August of 2019 in representing Michelle Troconis?
Yes.
Let's start with a general opinion from you. Did you form an opinion about the performance of Attorney Bowman in relation to the 3 police interviews that she participated in?
The Attorney Bowman's recommendation to meet with police on June 2nd.
I'm going to object. This is non-responsive. The question called for yes or no response. There's no foundation for this question yet.
Well, we'll deal with it one at a time. So first, answer the question, did you form an opinion?
Yes.
And what was that opinion in relation to whether Attorney Bowman's performance in relation to participating in those interviews met or fell below the standard of care for criminal defense attorneys in Connecticut in 2019?
That Attorney Bowman's recommendation to meet with police on June 2nd and subsequent dates without protection was not reasonably competent or within the standard of care.
Okay. we'll get back to the basis for the opinion in a moment, but you reviewed some materials related to the opinions in your testimony today.
Yes.
Start by asking you if you can run us through them, and then if there's more, I can ask you specific things. But what did you review?
Okay. And I'll try and take them up in the order that I reviewed them. And please keep in mind, some of these materials I had reviewed previously. I started with the appellate brief that was recently filed in the appellate court on behalf of Michelle Troconis. And then I looked at the revised corrected habeas petition in this case and the amended return. From there, I went to the 3 arrest warrants. The June 1st arrest warrant, the September 2019 arrest warrant, and the January 2020 arrest warrant. I also looked at Attorney Bowman's letter of August 27th, 2019. And I think at that point, I went back to the videos, which I had previously watched. But I watched the June 2nd video, the June 6th video, the August 13th video. I also watched the video of the transport from, I believe, Avon, but certainly down to the New Canaan Police Department. From there, I went back and I looked at the long form information because I wanted to be certain about the charges the operative charges at the trial. And I looked at the statutes that were set forth in the long form information. I read those statutes. From there, I went to the Connecticut Rules of Professional Conduct, looking at Rule 1.1, which is competence, 1.2, which is diligence, and 1.4, which is communication. And from there, I went to the ABA standards, focusing on the prosecution function standards and the defense function standards. And with regard to the standards, I was specifically looking for references with regard to cooperation. From there, I went to various provisions of ineffective assistance of counsel. In other words, black letter law, just to, refresh my memory. And then I looked at a whole host of individual documents. For instance, Attorney Bowman's fee agreement letter, Attorney Bowman's timesheets, the jail logs, another document which I understand to be a memorandum written by Michelle Troconis of her initial meeting with Attorney Bowman. I also went on the internet and was able to locate a videotape of the prosecution's rebuttal closing argument. And I did find that videotape and I watched that. And I watched it because it enabled me to see the slideshow that accompanied the argument. And now it comes to the transcript. With regard to the suppression transcript, I read the testimony of Attorney Bowman, Detective Kimball, Detective Ventresca. I read the oral argument at the end of the suppression hearing. And with regard to the trial transcript, I read the testimony of Attorney Bowman, Detective Kimball, Sergeant Ventresca, and also the witness Paul Gumieni. Correct me if I'm pronouncing his last name wrong. So there may be some other things, but off the top of my head, that's...
Can I walk quickly through those?
Yeah.
So, sounds like you didn't read the entire criminal trial transcript.
That's correct.
Tell me why.
Well, that was purposeful. I wanted to avoid the distorting effects of hindsight, but there was a need to look at the transcript, including the suppression transcript, for two reasons.
Tell me what those were.
Well, the first reason was I wanted to see if the transcript, either transcript, the suppression transcript or the trial transcript, revealed the presence or absence of any promises between the prosecution and the defense. The second reason I looked at those two transcripts was to see if any of the concerns that a lawyer would normally have when a lawyer recommends to the police that the client meet with the police, and let's say, for lack of a better way of putting it, things go south. Were there any of the concerns that a lawyer might have were realized in this case?
And were they?
Unfortunately, yes.
Can you tell me about that?
This is getting into the facts of the case. He's ultimately going to render an opinion on the ultimate issue. And so I would object on that basis.
Under 7-3A1, expert may give an opinion that raises an ultimate issue where the trier of fact needs assistance. I'll say that applies in this case. Overruled.
And actually, if I might maybe walk back to set that question up a little bit more clearly for the court.
I'll just add, I'm not sure that it embraces the ultimate issue in any event.
Is your opinion based on whether or not Michelle Troconis was convicted after trial?
No.
Okay. And those things that you said you were looking for, were they specific objective events that you were looking to see if they'd happened in the transcript?
So I would put them in a category. And as I said, these are concerns that a lawyer would normally have in any case when you have a client who's poised to cooperate. And broadly speaking, you're going to have three initial concerns: self-incrimination, risk of additional charges, and locking yourself in, yourself meaning the client, locking yourself in prematurely on a particular theory of defense. So broadly speaking, those would be the three concerns. And then I can articulate more specific concerns if you want.
And I guess for now, I'm just asking, you were looking for evidence of whether those concerns showed themselves in the criminal trial transcript. Is that fair to say?
Yes.
Okay. And you're not opining on how much of a difference that made in the trial or whether there was prejudice. Is that fair to say too?
Well, if you ask me to, and the court rules that I can, I would, but
I'm starting for now by saying the things that you just discussed were just whether they show themselves in the record as a starting point.
that was my purpose for looking.
Okay. And we'll get into sort of how it fit in, but you found things based on looking. Is that fair to say?
Yes.
Okay. And I'm going to just go through a few pieces of what you reviewed and ask you if you covered it. Did you review some or all of the appendix that was filed with the brief of Michelle Troconis?
Yes, I did.
Okay. And you said you looked at some case law. Was there a general review of ineffective assistance counsel cases, or were you specifically looking for anything, or what did you review in relation to case law on ineffectiveness?
I was not looking for anything in particular. You know, I've been a lawyer long enough and have testified enough times as an expert to know the black letter law, but just out of an abundance of caution, I like to review it to make sure that nothing's changed and I'm up to speed.
And did you do any research or find any cases more specific to the facts of this case that were related to your opinions?
I would say no.
Okay.
Yeah.
And if you already covered this, I apologize. But did you look at any treatises or professional manuals in preparing for your testimony?
Yes, I did. You know, over the years, F. Lee Bailey, the famous lawyer, has written a number of books and a number of treatises. And although there's repetition in all of these volumes, there are sections on representing cooperators. And I also, in one of the books, Attorney Bailey had some thoughts about the use of translators.
Okay. And does that cover the general, as far as you could recall right now, what you reviewed in preparation for your testimony?
I believe so.
Okay. In talking about the F. Lee Bailey books, was there any specific portions? I know you said about client interviews and all those things, but anything, if you recall now, that you looked at specifically that was relevant to your opinions in this case?
In the F. Lee Bailey publications that I looked at, there was a recommendation only to have your client cooperate in the most compelling circumstances and to memorialize agreements in writing and to begin with a proffer by the lawyer himself or herself.
And can you explain just a little bit what that means, the proffer to the lawyer as opposed to otherwise?
Sure. A proffer by a lawyer means a lawyer getting on the phone with a prosecutor or traveling to a prosecutor's office and simply saying to the prosecutor, here's what my client knows, here's what my client is prepared to tell you. Are you interested in that information? If you are, we can go forward to the next step. If you're not, then that's the end of it.
And going back to your opinion, what is your main opinion about Attorney Bowman's performance in relation to those 3 interviews in 2019?
Objection to question. It calls for the ultimate issue as well. Object to the form of the question, and secondly, that it goes to the ultimate issue.
I'm not sure it's the ultimate issue. It may be an ultimate issue, but the rule allows it if I permit it, and I will. So the objection's overruled.
It would be the same answer I gave you a few minutes ago, that the recommendation to submit to those interviews without any protection in place was not reasonably competent or within the standard of care.
And you reviewed the 3 interviews?
Yes.
And you reviewed the facts related to each of those interviews?
Yes.
And I'll also ask, were you here for Attorney Bowman's testimony?
I was here for Attorney Bowman's testimony, and I should add that when Attorney Bowman testified at the suppression hearing in 2023, I was in the courtroom for that.
So that opinion you just gave us, are there more specific parts of those opinions that we've discussed about Attorney Bowman's performance?
Yes.
Okay. And is there some general opinion that you have that applies to all 3?
The opinion I just gave.
Okay. And do you have opinions about specific interviews of the 3 interviews that took place? Just yes or no at this point.
The answer is yes.
Okay. So I'm going to start by asking you some general questions about all the interviews.
Okay.
And then I'm going to try to ask you questions about each individual interview. What does the standard of care require for an attorney that is contemplating advising whether their client should speak to the police in the circumstances that Attorney Bowman described in his testimony with Michelle Troconis?
I'm going to object because we may be approaching a Singh violation where you're asking one witness to characterize the testimony of another from the 2002 Connecticut Supreme Court case.
I'm not sure there's any violation. It's permitted by the rules. It's the same objection. The standard in habeas cases to have an expert testify as to whether a defense lawyer was ineffective. I'll allow it to overrule. Go ahead, sir.
Sir, can you ask the question again, please?
So I'll go away from what Attorney Bowman understood and say, in a circumstance when an attorney has a client who may be a person of interest in a serious criminal charge, where the police have indicated their desire to speak to the client, is there a standard of care that applies to that decision and that advice that you give surrounding any client in that circumstance?
Yes.
Can you tell me what counsel must do in those circumstances?
The standard of care involves a series of steps to be taken by the lawyer.
And does that involve anything directly between the lawyer and the client?
Yes.
Can you tell me about that?
I need a little bit of clarification in the following sense. We talking pre-arrest, post-arrest, pre-arraignment, post-arraignment?
Are you able to give me an opinion about pre-interview, about the decision to give an interview? Are you able to do that?
Well, yeah, the decision-making starts in the lawyer's office when the client is sitting in front of you. And you have a conversation with the client. It's something every reasonably competent lawyer would do. And there's about 4, 5, 6 areas that you're going to cover with the client. And that's essential. And that all takes place before you ever pick up the phone and call a police officer or a prosecutor.
Is part of that those things that you need to do discussing sort of your client's knowledge or understanding of the facts related to the case?
Yes, you would want to debrief the client. You would want to ask the client, what do you know about the matter that is under police investigation? That would be one of the 4 or 5 things you would ask the client about.
What else would you ask about?
You would ask the client, what interaction have you had up to this point with the police? Have you had any conversations with the police so far? And if so, what have you told the police?
And any other areas that you would cover in the interview?
Sure. You would have a conversation with the client about what the client's legal rights and obligations are with respect to talking to the police. Quite a few people have heard of Miranda and the right to remain silent, but yet a lot of people still don't understand that they have no obligation to meet with the police. They can politely say, thank you for the invitation, but I don't want to talk to you. So that would be part and parcel of the second thing that you would discuss with the client. The third thing would be the client's rights, procedural rights in court if an arrest is made. And then time permitting, and a lot of times time doesn't permit, so it carries over to perhaps another day. But time permitting, you would want to learn as much as you can about the client's life. And then finally, you would want to use that meeting as an opportunity to size up the client and sort of get a gut feeling for how a client responds under stress and how this client might do speaking with the police. Because often people don't change a lot. If somebody has difficulty in a law office communicating with a lawyer, it's easy to envision they're going to have that same difficulty putting their best foot forward with the police. So those would be the areas that a lawyer would normally cover. And of course, before the client leaves the office, there should be some brief conflicts check. The scope of the representation has to be determined. And the representation agreement should be reduced to writing. And if not, with an agreement that it will be reduced to writing within a reasonable period of time.
And so the things that you just covered as far as sort of maybe the preliminary investigation and interview with the client take you to the circumstances where an attorney knows that the police wish to speak to a client that also potentially could have criminal exposure in a serious matter. Do all those things apply to having been done that you just described before that decision can take place?
I'm sorry, can you identify what decision you're talking about?
So the decision of whether your client's going to make the decision with your advice, right? Is that fair to say?
That I think it's reasonable to conclude that the client is going to rely on the attorney's recommendation.
Okay, so I guess I'll skip ahead and ask you that. You talked about Miranda. Is the scope of the advice that a client needs simply what the advisement says? And when thinking about whether to sit for a police interview under those circumstances?
I think more time needs to be spent with the client on what are the advantages and disadvantages of meeting with the police. Simply saying to the client, you have to tell the truth, and any falsehoods that you convey to the police can be used against you. Could, with regard to some clients, be insufficient to enable them to really understand what's at stake.
And you asked a moment ago whether we were talking about pre-arrest, post-arrest, pre-arraignment, and all of those matters. Is there a different standard of care related to the decision in the first instance of whether to speak to the police at those different stages of the criminal process?
No, the standard of care would be the same.
And so at the time that the decision is made, counsel withdraw that. The decision in this case, you're familiar with the facts, was made after the first arrest of Mr. Troconis, correct?
Correct.
At the time that Attorney Bowman was considering the circumstances and considering what advice to give to his client, he would be incorporating all the representation before that, right?
Objection. How would he know that?
I'll sustain it on the ground it's leading.
So you went through the things that you would do with a client before making that decision based on the advice that you're giving. So,
well, I would call that step one.
okay.
But at the end of step one, you've not reached the point in time at which a decision is going to be made. You've just simply completed step one, which is to gather all this information from the client.
Okay. And then turning away from the client, is there other information that an attorney under the standard of care for criminal defense attorneys advising whether to speak to police? There are other steps that an attorney should take.
So whether or not a client's decision is an informed decision is going to be determined by whether the lawyer's recommendation is an informed recommendation. And after you've covered those basic steps with the client in the office, there's a lot more that has to be done before a lawyer can make a recommendation to a client to submit to an interview or to remain silent.
And should those steps include any investigation or gathering of information from somewhere other than the client?
Over the long haul, yes, but in the short term, that's difficult to achieve.
Why is that?
Well, because you can't put a team together in an hour or two.
And so if there's contact with law enforcement or the state about the desire for an interview, is there any duty that the attorney has during that contact related to the advice and decision that will later take place after that contact?
I'm going to object to the form of the question.
If you understand, go ahead.
I think I understand what you're asking, and I would answer it this way. When the client walks out the door and the scope of the representation is in place, the first thing the lawyer has to do is fax a letter over to either the detective or the shift commander or the chief of police, indicating that the lawyer represents the client and the client is exercising his or her right to remain silent, and no interview can take place unless and until counsel's present. That's the first thing you have to do when the client walks out the door so that you don't get caught short. And then the next thing you have to do is follow that up almost immediately with a phone call to the police. Hopefully the client has the detective's name and phone number or a business card. Follow it up. Have a conversation with the police officer. I'm so-and-so. I represent Jane Smith. It's my understanding that you're conducting an investigation and you would like to interview Jane Smith. Do you mind if I ask you what the nature of the investigation is? And with regard to my client, Miss Smith, can you give me an idea of the subject matter you're going to be asking her about? Have that conversation. Now, police can't make any promises, so there's no point asking, what are you going to give me in return? But you might say to the police officer, have you promised him or her anything to this point? It's not a long conversation because normally the police don't like to tell you a lot about their case. And of course, you're not going to tell them anything about your defense because it's a meet and greet. But you want to sort of conclude the call by saying, who's the prosecutor overseeing this case? And that's step 3. Get on the phone with the prosecutor. Find out. Are you actually overseeing the case? Are you familiar with the case? Have you been talking to the detectives? Are you in agreement with the detectives that there's a desire to interview my client? What can you tell me about the investigation? Every time you get on the phone with somebody, you're trying to take more than you give so that you can make an informed recommendation. And it's only when those calls are done can you have the client come back to the office and have an in-depth conversation about cooperation.
And during that in-depth conversation, start with this. If the police or the prosecutor has told you what they seek to interview your client about, or even the information they're seeking to obtain from your client, is there a duty to talk about that information with the client in that interview?
Absolutely. That's actually in more than one provision of the ABA defense function standards.
And when you talk to your client about what the police are looking for, what the state is looking for, should you also ask your client what they can tell you about what they would tell the police or the state about those topics?
Yes, you want to convey to your client the information that you learned. You want to convey to your client the information that the police are seeking, and you want to find out from your client, do you have that information? Is that information in your possession? And if so, how do you feel? How do you feel about conveying it?
Okay. And should you ask the client to convey that information? You should know that information that is to be conveyed during that interview, correct, with your client?
Well, you may have learned the information the first time you met with the client, but now you also know that police or prosecutors are interested in that information too. But if not, if you didn't learn of the nature of the information sought until you spoke with police or prosecutors, you would circle back with the client and say something to the effect, I spoke with the prosecutor. This is what they're looking for. Do you have that information? You'd have a discussion about whether or not the client has that information.
Are there any other steps that an attorney under the standard of care should take before giving the actual advice to the client about whether they believe that the client should sit for the interview?
Yes. Yes. You're still not at the decision point.
Okay.
The part and parcel of having a discussion about the client with the client about whether or not the client possesses that information would be to talk with the client about ancillary information, information on the perimeter of the essential facts being sought that might place the client in jeopardy, or to the contrary, might have some perhaps even unrecognized value to the prosecution. So you should have that conversation.
And is part of the standard of care in that circumstance to advise the client of the potential exposure under their version of events, either for the main issue that the police are interested in or those ancillary matters that might come up in the interview?
Yes, because some of the less essential facts could be pivotal in a prosecution of the client.
And at that time, does an attorney have a duty to give advice about whether or not they should, in fact, sit for an interview at that point?
Still premature at that point. There's still more steps to be taken.
What's next?
What's next is to get back on the phone and say the client is willing to come in. What is the state willing to offer? In other words, to seek protection. And protection can take a number of different forms.
And we talked about Ethley Bailey's treatise about the attorney providing the proffer, at least at the initial point. Is there a reason why that's advisable in those circumstances, having the attorney be the first one to lay out what might be available in an interview?
Yes, because it shields the client from a charge of any sort, because it's the lawyer making the representation. And it's being made in the context, in the broader context of a negotiation. So it would not be admissible. A prosecutor could not bring a charge against a client based on what a lawyer said over the telephone or in a prosecutor's office, which was simply just a proffer.
Is it fair to say that an attorney can't necessarily control what the state is willing to offer after you've taken all those steps and had that second phone call with them?
That's correct.
Okay, so would the advice or the duty to the client change based on how that phone call goes?
Yes, because you're going to find out in that phone call after you've conveyed to the prosecutor the information the client has, the client's willingness to share it, and you're going to have a response from the prosecutor as to what, if anything, they will promise or give in return. You're going to take that back to the client. And it's at that point that you're going to have a discussion about the advantages and disadvantages of going forward, whether the client, not every client is comfortable cooperating, and whether this is really something the client wants to do.
Are there other sort of situation-specific factors that might play into the type of advice that a client receives in those circumstances?
The seriousness of the matter under investigation.
Is there ever something called maybe the race to the courthouse or the race to the police station?
Sure. There are cases where there's an opportunity to cooperate, but it may be a short-lived opportunity. And so the lawyer needs to be concerned about not losing the opportunity to cooperate.
And that would be part of the advice the attorney would give in that circumstance?
Yeah, yes. You would have a discussion with the client about, look, there may be other people out there that have the same information that you have, and if they sit down with the police before you, then you may lose your value as a cooperating witness.
And so when that phone call happens where you go back to the state or the prosecutor, fair to say that you could get a promise of some sort or some protection out of that phone call? Is that one thing that could come out of it?
Objection. That calls for suspect.
Okay.
Thank you.
If a promise comes from that phone call, do you have to advise your client about what that promise means?
Oh, absolutely. You have an ethical obligation to advise your client of all communications there is an ethical obligation to advise the client of all communications between the lawyer and the prosecution.
And let's say, well, what I'll call a threat comes out of that phone call. Do you have to advise your client about that threat?
Yeah, I think that you do, yes.
And if that phone call is just strictly factual, do you have to advise your client about the strictly factual phone call?
Objection, Your Honor. These are a series of leading questions.
Overruled. You may answer.
The lawyer should just convey the contents of the call from beginning to end.
And does the duty in relation to that contents of that call end with just relaying the words that were said in the phone call?
No, you would want to, I'll say naturally, you would want to have a discussion with your client about the information that was conveyed.
Okay, let's assume that a threat is conveyed. Would you want to advise your client about any information or professional judgment you have about the likelihood of that threat being acted upon?
I'm going to object. It assumes facts, not in evidence.
It's essentially a hypothetical question. I'll allow it. Go ahead, sir.
Yes.
Okay. And the same with the promise. If, let's say, there's a looser promise that's given in a phone call, it'll all work out if you cooperate. Do you have a duty to your client to tell them exactly what that would mean in practice and how solid that protection would actually be?
Yes.
Okay. And are there any other steps before the actual recommendation to the client that we haven't covered so far?
Well, you would want, assuming that some protection is secured, you would want to explain to the client exactly what the protection covers. And you would also want to have a conversation with your client about the obligation to tell the truth and the risks associated with any falsehoods.
And a cooperation agreement, is the issue of whether it protects untruthful information Or what's the benefit of a cooperation agreement?
So, well, it's not just a cooperation agreement. There's a variety of agreements, beginning with a proffer agreement.
I'm going to object. This is becoming non-responsive.
I-
So it's cooperating agreements, not proffer.
All right. I'll rephrase your question.
What's the benefit or the protection that comes from a proffer agreement?
The benefit of a proffer agreement, and this assumes that the agreement that, because any agreement, no matter what its title, its value is going to be based on the language in it, not the title of it. Okay. But if we assume for the sake of argument that the proffer agreement protects the client from being prosecuted for any information conveyed, then that is the benefit of the agreement.
And is that information that's being conveyed, the protection, is that just to the central information that the state is seeking from the client?
Well,
And how do you know that?
I'll let the witness answer that question. Go ahead, sir.
Sure. I can ask it in general terms, and I would answer it this way. It all starts with what is the language in the agreement? Does the language say that the client cannot be prosecuted for any information conveyed, period? Or does it leave open the possibility that the client can be prosecuted for information, for identical information obtained from another source?
So is it fair to say that there's not one form agreement that applies to every case?
No, it turns on the language. Where the language doesn't change, and where I agree with Attorney Bowman, is that whether you're talking about a proffer agreement, a cooperation agreement, a plea agreement with a cooperation component, an immunity agreement, they all have one feature that doesn't change, is that if you lie and it's proven to have been a lie, you can be prosecuted for the falsehood. That is never going to change. But in terms of can you be prosecuted for other things you say, that's going to be more language dependent. Because a lot of people, when they meet with the police, they're telling the truth, but at the same time, they're also exposing themselves to criminal conduct. And that's where the agreement helps you. It doesn't help you in terms of lying. There's almost no protection for lying. The beauty of the agreements is that it insulates you, depending on the language, it insulates the client from being prosecuted based on the client's own words about the client's own, if any, criminal conduct.
I could just go through quickly that second call with the prosecutor, or the call about sort of the actual discussion that we're talking about. Go back into that a little bit. Are the things that I think we said that the attorney should find out what the matter is and what the police are looking for, or what the state is looking for. Is that fair to say?
Yes.
Should an attorney ask for any documents or information, if available, during that contact with the state at that point in the process?
Yes.
And what might you be looking for in seeking out documents at that point?
The arrest warrant.
Okay. Should an attorney at least ask what the state believes the client's role is in the matter being investigated?
Yes, that would be a question also to be asked of the police officer when you have that first call with the police officer. Where do you see the client fitting into the big picture?
Is it fair to say that police and the state might not always give you that information?
It's possible they won't give you that information, but there's no cost to asking.
And in the circumstances where there's some sort of coercion, threat, or aggression from the state or the police during those phone calls, does counsel have any duty in responding to that?
Yeah, I think in some circumstances the duty that counsel has is not only to push back, but to be as aggressive as the prosecutor was.
And you've heard the testimony about that phone call on June 1st between Andrew Bowman and Attorney Colangelo.
Correct.
And I guess we can assume that during that phone call, there was a discussion of that Mr. Troconis should cooperate. She should do it before the body was found, or she would be charged with accessory to murder. Assuming that for a moment,
Yes.
did Attorney Bowman have a duty to do more than just say, I'll talk to her and end the call at that point?
Yes, he did.
What was that?
He had a duty to push back and to demand what the basis would be at this point in time to say, what do you mean you're going to charge her with accessory to murder? Based on what?
And that based on what question? Why shouldn't an attorney ask that question in those circumstances?
The attorney has an ethical obligation. In fact, one of the ABA standards speaks specifically to this sort of a situation where the threat or the coercion or the urgency that is being placed on the defense lawyer is forcing the defense lawyer into an untenable situation, into a situation where the lawyer is forced to act more quickly than is prudent. And I think that provision is found in the prosecution function standards of the ABA, that a prosecutor should not put a defense lawyer in a position where a defense lawyer, because of coercion, is forced to make a particular recommendation to a client.
And is there any evidence that you are aware of that Attorney Bowman did respond to that coercion under the standard of care?
I'm going to object. Assumes facts, not in evidence.
The question asks the witness whether this happened. He doesn't.
But he was not present for the conversation.
I've ruled, sir. Go ahead.
The answer would be yes.
Yes, that there was.
Yes, there was evidence.
Yes. What was that?
The evidence was the testimony I heard at this proceeding that he just accepted what Attorney Colangelo was saying and had no response to it, and the phone call ended.
What's the consequence of not getting that information from that phone call with Attorney Colangelo?
The consequence of not getting that information is that you can't make an informed recommendation to the client. And if the client doesn't have an informed recommendation, then the client can't make an informed decision. The client has to be able to assess the risks of meeting with the police and the risks of not meeting with the police, and be able to assess the risk that there may be additional charges. I think under all circumstances, you have to take the threat seriously. Only the most cavalier lawyer wouldn't take the threat seriously. And that's not a problem in this case. He took the threat seriously. The problem is that he didn't push back. He didn't ask, what's that based on? Because had he pressed Attorney Colangelo, he would have gotten the answer that we got here today in this court.
I'm going to move to strike that last portion as speculative.
Overruled. It'll stand there.
And would a reasonably competent attorney, hearing that the only evidence was post-murder conduct, say that there was a high probability of being charged with murder as an accessory under those circumstances?
Can you ask that again, please?
Assuming hypothetically that based on what question had been asked, and the answer was, we have Ms. Troconis driving with Dulos, dropping off these bags in Hartford after we believe Jennifer Dulos was murdered. Wouldn't a reasonably competent attorney make an assessment of likelihood that that alone could form the basis for a charge of murder?
And I'm going to object to the
Basis.
There was no evidence that such took place during that phone.
Hypothetical bears a fair relation to the facts and evidence. It's admissible under 7-4 subsection C. Overruled. Let me answer.
I think a reasonably competent attorney had that discussion taken place between Attorney Bowman and State's Attorney Colangelo, had they had that discussion where Colangelo laid out what he thought the basis for an arrest might be, had they had that discussion, I think a reasonably competent attorney would respond. And I think a lawyer would respond in a way I think the response would be something to the effect of, that's a stretch. That's a stretch. If you're telling me that looking nervous in Starbucks is indicative of being involved in a homicide, that's a stretch. If you're telling me that a woman in a pickup truck on Albany Avenue, while somebody else is disposing of items in a receptacle, is indicative of being involved in a homicide, that's a stretch. I recognize that the probable cause standard is a low standard, but I think a reasonably competent lawyer would respond by saying, that's a stretch. And that discussion could unfold. But here's the overarching point. Even if he agrees with Colangelo, that's a great opportunity to say, well, if you really feel that way, Rich, if you really feel that way, then give me immunity.
Is there any evidence that any request was made to protect Michelle Troconis from Attorney Bowman to Attorney Colangelo during that phone call on June 1st?
None whatsoever.
And did not asking for protection in those circumstances meet or fall below the standard of care for criminal defense attorneys?
Objection. I still want to preserve the record that I'm objecting that it goes to the ultimate issue.
Objecting what? On what basis, sir?
That it goes to the ultimate issue. I just want to preserve the record.
Well, you've preserved the record, and the record is clear that it's a proper question under 7-3A, so you don't need to object anymore. You may answer.
It falls below the standard of care.
And you discussed sort of the opportunity to talk to Attorney Colangelo once that discussion takes place. Would that also inform the conversation to be had with Mr. Troconis after the phone call to have that information about, based on what?
Very, very much so.
Okay. And that's a lot of these questions about the decision to speak to the police in a circumstance that we've discussed. Does the client maintaining their innocence factor into the standard of care or the duty to the client in this part of the case?
No, the standards don't change.
And does reasonably competent counsel tell even an innocent client of the risks of speaking to the police?
Yes.
Okay. And if a client has maintained their innocence and there's been a discussion about that with the client and the attorney, does reasonably competent counsel advise a client that they should go and demonstrate their innocence to the police in all circumstances?
I don't believe a reasonably competent lawyer would ever put the onus on a client to go into a police interview and prove their innocence.
Why not?
Well, first of all, there's the presumption of innocence. The prosecution has the burden of proof. There's an imbalance of power. There is an imbalance of information, right? The police have done an investigation. They're not going to lay out all their evidence on the table for the client to review before the interview. It's the lawyer's job to protect the client's legal rights. It's the lawyer's job to make the case for the client. It's the lawyer's job to get on the phone and say, I think my client is innocent. I think your view of the case is wrong. But if my client comes in, here's what my client's prepared to say. It's not the lawyer's job to say to the client, go in and prove your case to the cops. That's ludicrous.
And as far as the lawyer's job, the lawyer's role in a case, how does a lawyer figure out what their role is or their job is in a specific case with a specific client?
The lawyer's number one job is to always protect the client's legal rights, whatever stage of the case the client may be in. I think that's the most simple way to put it.
Was it Andy Bowman's job to find Jennifer Dulos on May 31st, June 1st, June 2nd, 2019.
Object. Relevance.
I'll allow it.
Go ahead.
Physically find her?
Was it Andy Bowman's job to convince or make Michelle Troconis a tool in the investigation of the police in finding Jennifer Dulos in those circumstances?
No.
Was his duty to protect Ms. Troconis' interests?
Yes. I don't know, though, that he was making her a tool of the prosecution. I saw it as a difference of interest.
I'm just trying to be clear about what he's protecting at that point at the time or what his focus should be in giving that advice. Should it be narrowly focused on Ms. Troconis' interests?
That should be his sole interest.
And talking about that June 2nd interview itself, moving to it specifically, do you have a specific opinion about his advice related to sitting for that first interview?
Should have never taken place.
Why not?
I have 4 reasons. First of all, she was emotionally distraught. Second of all, she was exhausted. Third, it was anticipated that the interview was going to take place in English, which is not her primary language. And fourth, she was not a good candidate for a police interview.
We start with that last reason. What's your assessment of that?
There were 6 or 7 things I noted about the way she answered questions, the way she handled questions, the way she fielded questions that I thought did not make her a strong witness. And whether a client is a strong witness, a weak witness, or something in between is a fact that a lawyer has to take into consideration in recommending or not recommending that a client meet with the police. So, do you want me to go through the 6 or 7 things?
Yes, please.
So, these are just observations on my part. People can disagree, but
Before counsel identifies these supposed reasons, I still want to make an objection that we may be getting into an area involving where he's arguing from hindsight. So I just want to, again, I want to preserve the record. The court may disagree, but I want to make that record.
I'm aware of that. I'm aware of the case law. You'll have full opportunity to cross-examine on that and admit all the other points. Go ahead, sir.
So the 6 or 7 observations that I had that it caused me to view her as not being a strong witness were, number 1, at times she has difficulty answering simple questions.
Can you give an example?
Again, I'm sorry, Your Honor. The other ground, again, I just want to make the record. I'm not trying to be rude or be an obstructionist, but now he's asking this witness to assess the credibility of another witness, which is improper. And the court may disagree, but I want to make my objection known for the record.
I just have to say that that's not the question.
I understand he's really addressing the facts in this case. Go ahead.
So the second thing would be that at times she provides great detail on things that are not of consequence. And with regard to things that are really important, she often has very little detail. The third thing I noted was that at times she's not responsive to the question. The fourth thing I noticed is that she gives inconsistent answers sometimes. The fifth thing would be that at times she has uncertainty as to her answers, which may be perfectly appropriate based on the question. But in terms of putting your best foot forward and making a good impression with the police, uncertainty is not helpful. I think the sixth thing would be that sometimes she bases an answer on generalization or what they usually do. Again, not that persuasive. And then the last thing was something I picked up upon. I don't do a diagnosis. I don't do anything like that. But it just seemed that some questions she was fielding literally rather than in context. And she was missing the point of the questions. So if you look at all those things in their totality, at least on June 2nd, it didn't make her that in my view, that persuasive. Now, should Attorney Bowman, nobody's clairvoyant. So how would he know that if the interview hasn't taken place? But I think there were some signs that her performance on the June 2nd interview was predictable.
And I actually want to pivot back to something we just said to kind of maybe ask the next questions about your last answer. You said when I asked you about what Attorney Bowman's role was in the case, his duties or in being protecting Mr. Troconis' interests, I think your answer was that he didn't take up the law enforcement role. It's just that law enforcement and Mr. Troconis had different interests at that time. Was that your answer?
I saw them like two ships passing in the night.
And some of those things that you just talked about, those sort of factors that made her not a good candidate or not a good witness in the interview, were some of those perhaps part of that sort of passing in the night phenomenon?
I'm going to object because this calls for speculation. He's trying to read the mind of the defendant, and it is a sort of, I'm going to just say this for the record, from the respondent's point of view, it is his way of shielding the petitioner from possibly testifying in this case by getting into this area.
I don't sense that at all. He's assessing the petitioner as a candidate to speak to the police based on the record. Overruled.
Somewhat. I'm not.
So, in going back to, and you said he doesn't need to be clairvoyant, but given all those steps that you walked us through before, did Attorney Bowman have a duty to figure out what Mr. Troconis was going to say and compare that with how well or how not well that covered what the police might be looking for in that interview?
Well, there are two duties. He has a duty to get the facts from his client. And then if the decision is to meet with police, or if that's the decision being contemplated, to prepare the client for the interview or for a possible interview. So that's the duty. Yeah, that's the duty.
And when you said your observations about why perhaps the factors that make her maybe not the best witness in that circumstance, and I think you said that those could be disagreed with or could be disputed. But is there an underlying duty to at least make that effort to look closely at whether and use professional judgment about whether this person will be a good witness?
Yes, there is a duty to prepare the client, and if at the end of the preparation it is readily apparent that this client is not going to perform well in an interview with the police, to recommend that the interview not go forward.
And when you said two ships, is the one ship demonstrating Michelle Troconis' innocence? Is that the ship that Attorney Bowman seems to be on with his client?
Objection calls for speculation.
Well, it's leading. Why don't you just have him explain what he means?
Okay.
I didn't follow it either.
Sure. What I meant by two ships passing in the night, the police and the prosecution wanted to know what happened to Jennifer Dulos and where her body was. Okay. Andy Bowman was using the interview as an opportunity to demonstrate Michelle Troconis' innocence. He was not using it as an opportunity to answer the two questions that the police had. In fact, he knew that Michelle Troconis didn't have the information that the police had. So that's why there are two ships passing in the night. They each have a different purpose for the interview. But really, if you're in the game of trying to please the police.
Yeah, I'm going to object to that phraseology. There's no evidence of that. It's his own characterization of the testimony.
Go ahead.
If the aim is to satisfy the police, then the purpose that counts the most is the police purpose. What is what are the police trying to achieve?
And that answer you gave, was that specific to the facts and circumstances of the June 1st interview and what you know about the interview that Michelle Troconis sat for that day?
I'm going to object to that question. He's asking to characterize the interview instead of in a hypothetical.
Overruled. Can you ask that again? It's the June 2nd interview.
Yeah, the June 2nd interview. Is that answer you just gave about, for example, the game that Attorney Bowman was playing at that time? Is that specific to the goal of that interview that day?
Yeah. Well, if I used the word game, I'm sorry I did that, because there's nothing about this case that's a game. But the way I saw it, and based on the testimony that I saw in this proceeding, he indicated that his client represented she was innocent. He thought she was innocent. He was concerned about additional charges being brought. He felt that the interview would provide her with an opportunity to demonstrate her innocence. The police, on the other hand, had the expectation, because they were very clear about the information they were seeking. So undoubtedly, they had the expectation that she was going to come in and answer those two questions. And of course, she didn't. And that was the beginning of a downhill slide.
And would reasonably competent counsel understand the law enforcement goal of that interview to be getting information leading to the discovery of Jennifer Dulos' body?
I think the reasonably incompetent counsel would understand the point of that. The police could not have been more clear. This is what we're looking for. If they said it once, they must have said it 25 times. What happened to Jennifer, and where is the body? In fact, they stopped all three interviews. They stopped at various points and said, look, this is what we want to know. We'll listen to the other stuff, but this is what we want to know. Do you have the answer or not?
And so the other side of my last question is, would reasonably competent counsel understand that the police were not looking to simply clear Michelle Troconis in that interview or hear about her innocence?
I'm going to object. How would he know what the police thought? There's no evidence in the case. They did not testify.
I'll allow it.
Well, I think anybody that's practiced criminal law for a long time understands that the police, they're adversaries, and they're not. You would like to hope they're not in the business of prosecuting innocent people, but does that necessarily mean that in a police interrogation, their aim is going to be to help exonerate the person they're interviewing? I would think not. I think what the aim is in the interview is whatever they've identified as what's most important to them.
And you're aware of a prisoner's log in this case? Did you review that?
Yes.
And did you heard the testimony from Attorney Bowman about the meetings that he had with Mr. Troconis on June 2nd at the New Canaan Police Department?
Yes.
And could reasonably competent counsel feel like they are able to prepare a client for all the potential complexities of an interview like this in 9 minutes?
Well, it might be possible to do it in 9 minutes if there had been meetings with the client on earlier dates. But 9 minutes and nothing else, virtual impossibility.
So in assessing that 9 minutes of whether it's enough time, would reasonably competent counsel look back to whatever had happened with the client before that to see if that was sufficient to make the decision as far as the attorney's meeting and advice with the client?
Well, a lawyer in his or her mind always, in the back of their head, the lawyer always knows what's been covered with the client and what's not. What are the specific needs at a particular point in time. I mean, it really depends on what the prior meetings entailed.
And so the decision to talk or to maintain silence, does that end the second a client starts talking?
No, the client has under the Fifth Amendment the right to end the interview at any point in time.
So when counsel is present for a police interview under those circumstances, are there duties during the interview the counsel has of performance during the actual interview?
Yes.
And what are those?
to ensure that the client does not implicate himself or herself in any additional crimes, as applied to this case where you had Ms. Troconis, who was already under arrest and charged with hindering and tampering, to ensure that she didn't further implicate herself in those offenses, to ensure that she understood the questions so that she didn't give answers that were viewed as intentional, untruthful statements, because you don't want the client to get charged with giving a false statement to the police. So the duties of a lawyer in a police interrogation never end. You're not a potted plant. You're not just sitting there listening. You have to be on the edge of your seat, ready to intervene in a question if it's obvious that you have a client who doesn't understand the question. And although it's not pleasant to do, and although there is always the potential that, the police may get upset, you have to have the capacity to pull the plug on the interview if it's not going well.
And what about advocating during the interview or speaking up or interjecting? Is that something counsel has to do when appropriate?
Yes, and actually on June 2nd, it happened twice.
Okay. When did it happen, or what was the...
It happened twice, and it almost took the form of vouching, but it in my mind, it very much relates to whether her performance in that interview was something that Attorney Bowman might reasonably have anticipated.
Can you tell more?
Your Honor, the first interview is in military time.
Sure.
So at the 17:13 mark, which is towards the end of the first interview, Attorney Bowman says to the police officers, I want you to understand that her answers are not rehearsed, that all the questions you asked her today are questions that a lawyer would normally ask a client in the office. The other remark was at the 17:34 mark. And again, now it's even closer to the end of the interview. Attorney Bowman said to the detectives, the person that you're seeing is the same person that I saw. And I think a reasonable inference to draw from those remarks is that he was trying to aid her credibility because she hadn't performed well.
Objection, Your Honor. The basis is that he is assuming that Mr. Bowman was of the opinion that she did not perform well. He cannot read his mind.
Well, he's here as an expert to offer his opinion. That maybe this is his opinion. You can cross-examine.
I think the other inference to draw from that, if you look at the two remarks collectively, is that he might have anticipated this was how she was going to handle the questioning. I mean, if he went through all the same questions with his client that the police went through, and if he saw the same person that the police saw during the interview, then he knew he had to reasonably know the difficulties that she has answering questions.
You know, again, just for the record, I'm going to object to the last portion of the answer and ask it to be stricken. What he knew, there's no evidence of that. He is speculating. He's trying to read Attorney Bowman's mind.
Right. It's an opinion based on the record. Let me know, Mr. Brown, if this is a good time for our afternoon recess.
It is a good time.
We'll stand in recess for 15 minutes. I'll see counsel at the sidebar concerning schedule.
Your Honor.
Oh, I'm sorry.
Good afternoon. Please be seated.
Sorry.
Ladies and gentlemen, it's come to my attention that some members of the audience may be recording this proceeding, either visually or audio, other than members of the press who have permission to do so. That's not allowed. I know the marshals may have spoken to you about this. If I learn of anyone recording any portion of this proceeding, taking pictures, I will order that person be removed from the courtroom. I appreciate your attention to that matter. Continued direct examination, Mr. Brown.
Your Honor. I think that before the break, we were talking about the examples that you saw from the first interview of Attorney Bowman advocating in the interview. Did you cover both of them before the break, if you recall?
Yes, they were the two remarks he made towards the end of the first interview that I thought might, you might be able to draw the inference that he had a glimpse of how she would perform under the stress of the moment.
And if he had formed some judgment before the interview started about performance, does the standard of care require that he advise the client about those judgments?
The answer is yes, but the overarching question would be, do we need more preparation before we submit to this interview?
And you've heard Attorney Bowman testify about the time pressure reasoning that he had or information that he had before that first interview. Were you here for that?
Yes.
Under the circumstances of this case, would a reasonably competent attorney have at least explored whether the interview, if it was going to take place, had to take place there and then when it did?
Yes.
Okay. And what are some of the things that an attorney would look at with that circumstance?
A reasonably competent attorney would explore the possibility of doing the interview on a later date, even if it's just 24 hours later. That would give the lawyer and the client more time to prepare. And that's particularly true in a situation where the determination has been made to go forward without any protection in place.
And in the first interview, you aware of a circumstance related to Mr. Troconis, a discussion of Mr. Troconis' language, in Spanish speaking and English?
I'm sorry, I didn't hear the question. I'm not objecting. I didn't hear the question from Mr. Brown.
I think I mumbled it, so I'll say it more clearly this time. Are you aware in the first interview of a point in time where Mr. Troconis raises the issue of language, Spanish speaking?
Yes.
Do you form any opinions about how that Attorney Bowman's performance played out in that circumstance?
I thought there were 3 or 4 potential flaws there.
Can you tell us?
And let me put it this way. The question about language is also tied to the Miranda waiver. So this answer is going to speak to both. I thought there were 3 or 4 flaws there. When the police interviewed, Your Honor, when the police entered the room, the first thing they did was say something to the effect of, "We're going to go over some documents with you." And Attorney Bowman immediately said to Ms. Troconis, "That's a formality." I thought that was significant in 2 ways. First of all, it had the effect of trivializing what those documents represented, which is the waiver of constitutional rights. That's a big deal.
I don't mean to be difficult, but this is mere speculation on this answer. I know I sound like an obstructionist, but I want to protect the record and preserve it for appellate review that I object to this line of questioning, that it calls for speculation with him characterizing it.
I think he's characterizing defense counsel's conduct, which is his role, at least to offer an opinion as to that. Go ahead, sir.
So as I indicated, he said to Ms. Troconis, "That's a formality," which a client could have the effect of trivializing the importance of the document. But the other thing that was telling about the comment was he didn't say to her or anything to the effect of, "What he's going to show you is what we were just talking about in private, or what we were talking about this morning when I met with you privately." And so what's the inference you can draw from that? The inference you can draw from that is that, yes, he told her that you're going to be waiving your rights and you have to tell the truth. And if you don't tell the truth, yada, yada, yada. But what it tells me is that they never really had a serious, meaningful, in-depth discussion about the repercussions of waiving your rights, talking to the police, and how south things can actually go.
Again,
So that was the first flaw.
I am going to move the strike. He was not present for any of these conversations. He's merely speculating and making assumptions and being presumptuous.
The motion is denied. I don't believe it's speculation. I believe it's an opinion, which he's entitled to give. Overruled.
The second flaw that I saw was that he spoke for the client. He said the client doesn't need an interpreter.
Why is that a flaw? Why is that a problem?
Well, because English isn't the client's first language, and the client knows best what the client can handle. And so so what does that say? What it says is that at some earlier point in time, whether it was 10 minutes earlier, 2 hours earlier, 2 days earlier, they didn't have a conversation about whether it would be advantageous to have an interpreter present if you meet with the police. Meeting with a client in the office is not on the same scale as meeting with the police, where you're held to every word, where there are risks to what you say. The third flaw that I saw was that there was an English version to the waiver on the opposite side of the document. This was a 4-hour interview. Who cares if it was a 4-hour and 5-minute interview? He could have just simply said, why don't you flip that over out of an abundance of caution and read the Spanish side of it. Didn't necessarily have to execute the Spanish side, but at least read it. I mean, there was so much at stake here in this whole thing about an interpreter and Miranda. What was really, there was just no importance to it.
And you talked about a conversation between a lawyer and a client in their office versus what's at stake in a recorded police interview. What's the distinction there? Can you talk a little more about the distinction between circumstances?
Yeah. The distinction is you're not going to be charged with a crime for something you say to your lawyer in your lawyer's office. Yeah, you're not held to your answers.
And in the issue of language with a client, does a client have to be completely not at all able to understand in order to protect the client's ability to understand the language that's being used? If that question makes sense.
I'm not sure I'm following you.
Okay. It's clear from the interviews that Mr. Troconis speaks some English.
I'm going to object. He's characterizing the.
All right, well, just ask questions. So
Yes.
Steve.
Okay. Does the fact that Mr. Troconis is able to speak English in the interviews mean that the issue of language could not be relevant to what's happening in that police interview?
The fact that she can speak English and did speak English in those interviews does not make the issue of language irrelevant.
Why not?
Why not? Because of what's at stake. And more importantly, because the presence of an interpreter may have been advantageous to her in those moments during any of the 3 interviews where she needed the benefit of a person that spoke English and Spanish.
And the idea of the interviews is withdraw that. So is there any issue that you're aware of as far as their care goes with interpreters during a police interview at the police station?
There's no hard and fast rule that says that a lawyer has to have an interpreter for a Spanish-speaking client in a police interview. It's going to be taken up on a case-by-case basis. It's going to be fact-driven. It's going to be driven by discussions between the lawyer and the client. I mean, that's really the most important thing. Did they talk about whether or not it'd be advantageous to have an interpreter and so that the client can make an informed decision?
Were there indications in the first interview that would have been relevant to Attorney Bowman's assessment of continuing cooperation, that the police did not believe what Mr. Troconis was saying in that interview?
Yes, every time the police paused and advised Ms. Troconis that they didn't believe her.
That did happen in the interview on one occasion?
It happened on multiple occasions
Okay.
during that first interview, yes.
Would a reasonably competent attorney have felt the interview on June 2nd was going well for the goals of the client in that interview?
No,
Why not?
because it didn't go well at all.
I'm going to object because now he's assessing, he's giving his own opinion, presumably with the benefit of hindsight. And I just want to preserve my objection for the record.
Right. Those sound like good points to raise on cross-examination, but it doesn't affect the admissibility. Overruled.
Continue your answer.
Not only did her performance on June 2nd raise doubts about her credibility, but her testimony, her statement, her answers about being on Albany Avenue breathed life into that videotape in a way that was harmful to her.
And did Attorney Bowman ever terminate the interview based on how the interview was going?
No,
Would reasonably competent counsel have at least strongly considered doing so in those circumstances?
yes,
And did you form any opinions about the position that Mr. Troconis was in? Would strike that, please. Form any opinions about Attorney Bowman's performance related to the decision to sit for the second interview on June 6, 2019?
yes.
Are there generally any new considerations that an attorney would have under the standard of care at that time about whether to continue with the attempts to speak to the police?
There would be two considerations.
What are those?
The first consideration would be, how did the client perform in the first interview? And the second consideration would be, given the police purpose of the interview, does the client now have the information that the police seek?
And would reasonably competent counsel make any attempts to explore with the state or with the police sort of what the goal on the state side would be for a further interview?
It wouldn't take much exploration, because the police could not have been more clear in what they were looking for. They said it, even as Attorney Bowman put it in his testimony today and on Monday. They repeatedly said, we want to know, the police repeatedly said, we want to know what happened to Jennifer Dulos and where is her body. And that was the police purpose in the first interview and the police purpose in the second interview.
Okay, and exploring whether to sit for a second interview, does the standard of care require counsel to do anything with that information about what the police are seeking with the client?
Yes.
What's that?
Make a better recommendation.
Okay, and what would the standard of care require as far as a recommendation goes as sitting for the second interview in these circumstances?
Not sit for it.
Okay. Why not?
Because there is no reason to believe that the client on June 6th is suddenly going to know what happened to Jennifer Dulos and where the body is. There's no reason to believe that. She hasn't said that to her lawyer up to that point, and she's told both her lawyer and the police that she doesn't have the answers to those two questions. So there's no reason to believe that is going to occur. And there's no reason to believe that she's going to perform any better than she performed in the last interview.
Asking sort of the other side of that question, are there circumstances that reasonably competent counsel in that situation would reasonably say a second interview would be worth it for the client?
In that situation?
Well, what circumstances
could there be a situation?
Yes.
Yeah, there could be a situation.
What are some of the things that reasonably competent counsel would be looking for in making that decision to potentially reasonably sit for that second interview?
That the person does know what happened to the deceased and where the body is, that the person has additional, what I'll call ancillary information that might be helpful to the prosecution in other ways, that the client made some statements in the first interview that need to be corrected. So those could be situations where there would be reason to have a second interview.
If reasonably competent counsel found those circumstances where it might be reasonable to sit for a second interview, would reasonably competent counsel simply schedule an interview and sit down?
No, counsel would want to explore, go through the same steps that preceded the first interview. Proffer by phone, a possibility of proffer agreement, possibility of a cooperation agreement. He makes the good point. Her credibility is diminished at that point. Probably not going to get any agreement, not going to get anything in return. He makes a good point, but that doesn't excuse him from not asking.
And could there be something like a soft proffer where counsel says, this is what my client would bring to a second interview? Can you tell me if that would be valuable to you, or would you tell me and just try to seek out information from the state about their position on that new information?
Yes. When I say proffer and you say soft proffer, we're talking about the same things, as to be distinguished from a formal proffer agreement.
Okay, but there would be steps that counsel would take similar to what we discussed before the first interview, considerations about what to do with that information and what value it would have for the state. Is that fair to say?
Right, because you don't want to go in there and just bang your head against the wall and have a replay of what took place 4 days earlier.
And from your observations of the testimony in this trial so far, the second interview, was there any information that was brought to that interview to meet the goals that the police had or the state had from what they wanted from Mr. Troconis?
No. Right at the very beginning of the interview, the police said to her, we want to know what happened to Jennifer Dulos and where the body is. And they made it crystal clear what they were looking for, what the purpose of the interview was, and Ms. Troconis started to provide information that was not responsive to the purpose of the interview.
And from your review of the interview, did the police articulate their view that it was non-responsive to the stated reason for the interview?
Yeah, the interview went terrible. Absolutely
object
terrible.
to that characterization, Your Honor. That's an opinion. Again, it's fact. He's characterized, again, from the benefit of hindsight.
Right.
I know. I just want to, again, reserve my objection for the
I
record.
think you've done that. It is an opinion, and he's entitled to it. You may proceed.
Are there indications in the second interview that where the police in the interview articulate that they don't want what is being offered? They're not looking for what's being offered?
Yes, I think the first 11 minutes, Your Honor, of that June 6th interview encapsulates what took place that day and how much things unraveled and how unhappy the police were with what she was poised to tell them.
Again, use of the word, when he said the police were unhappy, there's no evidence of that on the record. He's speculating about what they were thinking. Again, I want to make the objection known that he's commenting about facts, not in evidence.
All right. Well, you can ask him on cross-examination.
That answer you just gave about the police's unhappiness with the answers, is that based on words that you hear spoken by police officials during the second interview?
Yes, it's on videotape.
Okay. And are you able to summarize what sort of the stated goal becomes quickly in that interview, that the police, what they want Michelle Troconis to produce?
The same goal that they had in the first interview. They wanted to know what happened to Jennifer Dulos and where was the body.
Is it clear in that first 11 minutes that Michelle Troconis has not come to give that information?
Objection. How would he know that? Cause speculation of what she's thinking.
No speaking objections, sir. The witness is entitled to give his opinion. Oh.
I think she said twice in the first 11 minutes she didn't have that information.
And these questions I'm asking you, you're answering based on what the stated words are. You can't read anybody's mind on a videotape, right?
That's correct. I'm just taking the videotape at face value and what the exchanges were between Ms. Troconis and the police and the when Attorney Bowman, interjected. That's all.
At face value, that first 11 minutes of what the word stated, did reasonably competent counsel have a duty to do anything at that point in time?
Yes, a reasonably competent lawyer would have stopped that interview.
And I'll give you a hypothetical. The police want to talk to your client about a very serious matter. They believe that you had a lesser role, your client had a lesser role than someone else. There's been a first interview where the police think your client's been untruthful. Your client has not given you any new information after that first interview. Does the standard of care allow for an attorney to hope that their client will, for the first time on camera with police there, tell a truth that had not been told in the privacy of the attorney-client relationship?
No reasonably competent lawyer would expect that to occur, that all of a sudden the client would produce this information. Anybody with any degree of common sense wouldn't expect that to occur.
And even if the expectation, putting aside the expectation of it happening, are there risks that reasonably competent counsel would understand to hope the information to come in that manner?
Say that again, please.
I'll ask it this way. Would reasonably competent counsel want to hear the information from the client outside of the interview before hearing it for the first time in the interview with the client?
Yes. Hypothetically speaking, if a client was going to admit to serious conduct or divulge a particular fact that was really important, I would think any lawyer would want to have a heads up on that before the client did it for the first time in an interview.
And whether there was any formalized protection for the client doing that factor into whether an attorney would even be in that position, with hoping the client gives it up, so to speak, with the police for the first time without having told that to the attorney beforehand?
It's just the whole thing is attendant with risk.
Is your understanding of Attorney Bowman's testimony that he was hoping for Ms. Troconis to say something in that interview that she had not previously said to Attorney Bowman before the interview?
Objection. Again, it calls for speculation about what Mr. Bowman was thinking with no evidence of it.
Overruled. Waiting answer.
Based on the testimony in this proceeding, it doesn't seem, based on his answers, it doesn't seem that he had an expectation that at that second interview, she was going to tell the police what had occurred and where the body was. Based on the testimony he gave in this proceeding, he testified that he was going to use the second interview to clean some things up and to rehabilitate her and to work on her credibility. And it just didn't work out.
Do you have an opinion about whether that expectation of that goal was reasonable based on the information that Attorney Bowman testified to having before that interview?
I think the expectation of the goal was unreasonable, and it may have been his goal, but I don't know if that would have been a goal impressive to the police.
So one moment, I am good to the end of this, but so after the second interview, what would reasonably competent counsel do at that time based on advising the client whether to continue talking to the police for further interviews?
I believe the advice at that point by a reasonably competent attorney would have been not to meet with the police again.
And the circumstances after the second interview, would reasonably competent counsel have felt like, well, strike that. based on the circumstances after the first two interviews, would reasonably competent counsel conclude that the process had been going favorably to Michelle Troconis up to that point, as far as her decision to speak to the police?
Well, if that reasonably competent counsel was sitting for those first two interviews, I believe the recommendation would be not to proceed with a third interview.
And could there be circumstances after the second interview where reasonably competent counsel would consider advising the client there might be a benefit to a third interview?
Only if the client came forward with new information, or, somehow the lawyer was able to, at that point, pull a rabbit out of a hat and get an immunity agreement, which I agree with him at that point. Basically you can kiss that goodbye.
And if the client had come with some potentially new information, would the standard of care for an attorney be to schedule the interview or take other steps before moving into that third interview?
Maybe it's me because it's late in the day.
Yeah.
Could you ask that again?
Okay. So hypothetically assume that the client does come forward with some sort of new information.
Okay.
Would reasonably competent counsel simply schedule a third interview, or would competent counsel take other steps at that point, maybe similar to the earlier points in the case?
The earlier steps: assess what the information is, determine its value, have a conversation with the prosecutor to, make sure the client's willing to turn that information over, to divulge it. Have a conversation with the prosecutor or the prosecutor, determine whether or not some protection can be gained, and, at that point, make a recommendation to the client, counseling the client again, just like all the previous times. What are the advantages and disadvantages to going forward? Is there protection? Is there not protection? Without the protection, what are all the bad things that can happen to you?
And even if the client came with new information that could potentially be helpful, would that necessarily change the advice to you should, in fact, continue to talk to them?
It turns on the facts and circumstances.
And we talked about the decision to talk to the police.
Yes.
Whose decision is that ultimately?
In the end, it's the client's decision.
In a criminal trial, there is an absolute right for a client to testify, correct?
Correct.
Is that the same calculus with the decision to talk to the police?
I would say yes.
But even with the right to testify at a trial, that decision must come with advice. Is that fair to say?
Right. A client can only make an informed decision if the client has informed advice.
And if in the position that Attorney Bowman found himself in, either after the first interview or the second interview, where reasonably competent counsel would conclude that it had not been going well so far, would reasonably competent counsel continue the talking with the hope that things would change direction?
No.
Why not?
Because you can't chase your losses. You cannot chase your losses. You have to recognize that things have not gone well. A lot of damage has been done, and going in a third time is not going to make it better. You have to accept sometimes in this business the fact that you're not, if you ever were, you no longer are in a strong position, and you're just going to have to deal with the consequences of that at that point. But to go in for a third interview thinking that you're going to make everything right is foolish. It's just wishful thinking.
And is that part of the advice that you would reasonably competent counsel would give to their client in those circumstances?
Yes.
Okay. And you reviewed the third interview on August 13th, 2019?
Yes.
Based on the words said by law enforcement during that interview, did they make statements that reasonable competent counsel would understand to mean they were not satisfied with the information that Mr. Troconis was giving at that interview?
Yeah, it's not even a matter of drawing an inference. They were very direct. They didn't believe her. They were upset she didn't provide it. They thought she had the information and that she was withholding it. And the fact that they were experiencing this for a third time was upsetting to the police.
And
I'm going to, again, I just want to make the record. I want to strike the last portion of the answer as non-responsive.
Well,
And that-
it's answering from the perspective of defense counsel, which I'll allow. Overrule.
in all three of the interviews, did you see examples of pressure or even coercion being exercised on Mr. Troconis by the police in the interviews?
I'm going to object to the form of the question. It's overly broad.
Allow it.
Can you explain what you mean by coercion?
Well, I'll take that coercion and start with just pressure. See examples of pressure being exerted by the police on Mr. Troconis during the interviews.
That's hard to answer because I'm not in her head. The things the police said may have caused her to experience pressure, like, we're going to charge you, or, I mean, there's just plenty of examples where she may have felt pressure based on things they said, but.
Example, discussions of the petitioner, Mr. Troconis' daughter, being used during the discussions when Attorney Bowman was there in the interviews. Did you see examples of those?
I saw that. Yes, I watched the videotape. I saw that.
And whatever the examples are of pressure, however you characterize it, is the fact that that could be part of the process something that a reasonably competent counsel should advise their client of before the initial decision to talk to the police?
I'm sorry, I didn't hear the question. Can Mr. Brown please repeat it?
If you would.
Should issues of police pressure, police tactics, police coercion even be something that would be discussed with the client as part of the advice before any initial talking to the police happens?
Yes.
Does reasonably competent counsel advise their client that the police can lie to them,
Yes.
can yell at them,
You should indicate to the client that it's a possibility.
and reasonably competent counsel, would they try to protect the client in the interviews against some of those things?
As part of a lawyer's overarching duty to protect the legal rights of the client, the lawyer should take measures to ensure that the client's not experiencing coercion.
However, as far as the advice at the beginning of the process, some of those issues, is that part of the decision whether part of what a client should know as part of whether they should cooperate in the first place or speak to the police in the first place?
Sure. Prior to any interview, when you're having a discussion with a client about what the police interview might be like, you should explain to the client that it could become a highly pressured setting.
And how that particular advice gets given, is that maybe different for different attorneys and under that same standard of care?
Yes, there's no book to pull off the shelf to say that this is how you counsel the client on undergoing a police interview.
What about advising a client that even if they don't confess, so to speak, in the interview, that things from those interviews could still be used against them? Is that part of the standard of care to give that advice?
It's part of the standard of care, and it's what lies at the heart of this case. This is why she got convicted.
John, I'm going to object to the last portion.
I'll sustain that objection and disregard the last comment.
Is it a reasonably foreseeable consequence that a client should be advised about by reasonably competent counsel that things other than a full confession could be used against them in a criminal prosecution?
Absolutely. Earlier in my testimony, when I used the phrase ancillary information, that's what I'm talking about.
And at the time of each interview, pull it back and ask this way. Do you know what the charges were for Mr. Troconis at the time of the June 2nd, 2019 interview?
Yes.
What were they?
Tampering with evidence and hindering prosecution.
Would reasonably competent counsel limit their advice to the client's exposure on those then existing charges in this situation?
No, that would be, the advice would be too narrow. The advice that you give the client would not only address the existing charges, but also the criminal investigation of a homicide that's underway, potential homicide.
And would the statement by Attorney Colangelo about his intentions or potential intentions make clear that this potentially was about advising in relation to a homicide prosecution of the client. Probably a confusing question. If on May 29th, it wasn't clear that Mr. Troconis was a target in a potential murder investigation, is it fair to say that on June 2nd, after that phone call with Richard Colangelo, Attorney Bowman and any reasonably competent counsel in his position would understand that it was more than tampering, it was more than hindering, it was potentially a murder representation?
Yes, if it wasn't clear before then, it would have been clear when he hung up the phone with Mr. Colangelo.
And that advice initially about whether to talk or not, would it encompass the possibility of more charges than where Mr. Troconis started in this case?
It has to, because one of the concerns is that if the client submits to the police interview, is the client going to, for lack of a better way of putting it, walk herself into additional charges?
And you heard Attorney Bowman's testimony, and you watched the interviews about some of these other pieces of information that Mr. Troconis had indicated she had received from from Mr. Dulos and from other people before and at the time of the disappearance.
Yes.
In your opinion before about reasonably competent counsel taking up the role, trying to advocate for the client's innocence in the first instance, would that include presenting information of that nature?
It might.
The basis for the client's beliefs or understanding of the circumstances?
Yes.
Okay. And does the duty of an attorney to advocate when the client is trying to express those things in an interview, is that part of the standard of care?
The duty of the lawyer to advocate when the client's trying to express those things in an interview?
So in the interviews, did you observe Ms. Troconis trying to talk about her belief that Jennifer wasn't even dead and the basis for that? There's part of that, would you agree?
Yes.
And then there's there's discussion by Ms. Troconis about why she didn't believe that Mr. Dulos would have any motive to kill Jennifer.
Mm-hmm.
Does that duty to advocate for the client include attempts to make clear at least what the client is trying to say in those circumstances?
It's certainly to interject during a police interview and ensure that the client's answer is responsive to the question, or that the client even understands the question, is certainly not outside of the standard of care. There's nothing within the standard of care to say you have a express duty to interject. But just good lawyering dictates that that's something you do when you get a sense that the client is having a hard time with the question.
And it's about whether you even sit for the interview to have the client prove their innocence themselves. Would the standard of care include understanding those things that the client is telling you and attempting to present them to the state yourself if you found them valid?
Well, I think it's just silly to think that a client's going to go into a police interview and prove his or her innocence. I mean, well, that happens like once in a blue moon. And from the police perspective, that's not what they were interested in.
We walked through general advice and we walked through each interview. Did you form an opinion about whether each interview was ill-advised under the standard of care for Mr. Troconis?
Yes.
And were the lapses in the standard of care from Attorney Bowman independently subpar for each interview?
Objection leading.
All right, would you rephrase?
Yes. Do you have an independent interview, or sorry, it is late in the day. Do you have an independent opinion of each of the three interviews about whether the standard of care was met?
Yeah. The recommendation in each of the three instances did not meet the prevailing professional norms.
For the reasons we've discussed?
Yes.
I have nothing further. Thank you, Your Honor.
I can begin, Your Honor.
cross-examination when
Yes,
you're
I
ready.
know we have about 28 minutes left, but I'll begin.
Yes, we'll end it shortly before 5. Let me just state for the record that members of the audience may want to know that we may resume this trial on Tuesday. That's something I have to determine with counsel at the end of business. Are you available Tuesday, Mr. Fitzpatrick?
I think I am, but I'd have to consult my calendar, which I have with me over near council table.
All right, thanks. So after court, we'll do all that. It's a possibility. I'm not sure whether it's a certainty yet. When you're ready, Mr.
Thank you.
Zentner.
Okay, Mr. Attorney Fitzpatrick, when you said you were first retained by Attorney Brown in November of 2025?
Yes, November 21st, 2025.
Okay,
That's what I'll describe as the official date.
okay. But you also said you had been retained by Attorney Schoenhorn previously, when Mr. Schoenhorn represented Ms. Troconis, right?
That's correct.
Okay, and you were ready to testify at a suppression hearing on or about December 18th of 2023.
That's correct.
Okay. And you indicated you reviewed a number of materials before you were going to testify at the suppression hearing from December of 2023, right?
The materials I listed were the materials I reviewed prior to this hearing. Some of them I had received previously from Attorney Schoenhorn.
Okay. You said earlier in your testimony that you charged $350 an hour for your time as an expert.
That's correct.
What were you charging in the year 2023 as an expert per hour?
Can you get a more specific question? Is it this case, all
Yes,
cases?
with respect to this particular case,
Mhm.
then it was called State versus Michelle Troconis. Let me ask you this. How many hours do you think you reviewed in the Troconis matter before you were going to testify at the suppression hearing? How many hours do you think you put in?
I'm going to say about 40 to 50.
40 to 50. And what were you charging Mr. Schoenhorn per hour with the 40 to 50 hours?
I think it was 600.
600 an hour then?
Yeah,
A little bit more than you're charging today.
that's correct.
And were you paid that amount, $600 an hour?
I think I discounted the bill by 8 to 12,000.
Okay, what was the total bill then that he paid you?
I think that I think it would be in the 20s. 600 an hour, 40 to 50 hours, it'd be about 30,000.
$30,000.
Well, no, I'm doing the math out loud.
Well,
If I had 40 to 50 hours
Okay.
at 600 an hour, let's round it up to the 5. That would be $30,000. 50 hours at 600 an hour would be $30,000. But I do remember at the end, I just counted one of the final bills by 8 to 12,000. So I think there were probably more than 40 to 50 hours.
Okay, because that would include your time sitting in court watching the testimony like you did for this trial at the suppression hearing, right?
Well, there was not very much testimony watching. The only testimony I watched in the original suppression hearing was Andy Bowman's testimony.
And you were compensated for your time to sit and watch, right?
Yeah, I think his testimony took an hour or less.
That would include travel time to and from the Stamford courthouse, right?
I don't think I charged for travel time.
You didn't charge from Bridgeport to Stamford?
No.
Was that in the morning?
Was it in the morning?
Yes.
Yeah.
Obviously, there's much more traffic on the morning going from Bridgeport to Stamford in the morning. Was it in the morning?
Yeah, probably was.
Okay, so you were probably stuck in traffic and it would have taken you maybe an hour to get there from Bridgeport.
Sometimes it takes longer than an hour to get from Bridgeport to Stamford.
Okay.
Yeah.
Okay, so when I say that they paid that bill, it was really the Troconis family that paid that bill through Mr. Schoenhorn, right?
I don't know.
You think Mr. Schoenhorn just paid it?
I don't know. Attorney Schoenhorn, the check came from his law office.
Okay, but where do you think he got the money from?
I object to the relevance of.
I'll sustain it on the ground that he said he didn't know.
Did you even ask who it came from?
Well, it's obvious who it came from.
Okay, I just want to be clear so the record's clear. Who do you think it came from?
It came from the Troconis family.
Okay. And it was Attorney Schoenhorn's intent to have you testify at the suppression hearing before Judge Kevin Randolph, right? On December 18th of 2023.
That's correct.
Judge Randolph, however, decided you could not testify and precluded your testimony, correct?
That's my understanding. I was asked to step out when apparently he made the ruling.
Okay, but you said earlier in your testimony on direct, you read all the transcripts relative to that suppression hearing. Did you see Judge Randolph's basis for excluding your testimony?
He said he reviewed them, not that he memorized them. So
He said he wasn't there.
Yeah, but he said he reviewed the transcripts of that suppression hearing.
Okay.
I looked for that very answer.
Did you find it?
I didn't find it, and then I investigated why it wasn't in the transcript.
It wasn't at all.
No.
Did you look at his memo of decision dated December 20th, 2023?
No.
You didn't look at that at all?
As to why my testimony was not permitted?
That would have been included in the memo of decision by Judge Randolph. So my question to you is, did you review Judge Randolph's decision denying the motion to suppress her statements in toto?
I believe I reviewed a part of it, yeah.
You reviewed part of it? Did you see that part in the memo of decision?
No, I didn't.
Did you think that might have been important?
As to why he denied my testimony?
Yes.
No, I think it would have been important to John Schoenhorn, but not to me.
Okay. You just have a moment, please, Your Honor.
Yes.
You just have a moment, a little further. Okay.
907 leave handbooks. That's
I'm just looking for my notes on something. You said you read part of his decision, Judge Randolph?
I feel like I did because I feel like there are some parts of the decision that I recall.
Okay. Do you remember? You would agree when Judge Randolph is presiding over that hearing, his role is to be a neutral arbiter of the facts and the law. Would you agree with that?
Yes.
Okay. In other words, he's supposed to be neutral when he hears the evidence. You would agree with that. He's not an advocate, correct?
Correct.
Okay. In his decision, he expressly found that Michelle Troconis was alert, didn't he?
I haven't read that. I have not. If you have that decision cover to cover, that's not a document I have. I feel like I'm familiar with parts of the decision, perhaps from reading the appellate brief. But if you're asking me about specific things he said in the decision, I'm not going to be able to answer those questions.
But when Judge Randolph was sitting and listening and observing and all the testimony that was presented from the officers who interviewed her, Mr. Kimball, Mr. Clabby, Allison Peters, Ventresca, all of them testified. And then Judge Randolph decided, after hearing all the evidence, to deny the motion to suppress the statements in toto, correct?
I object to the characterization that he heard all the evidence.
Well, just ask questions. Don't make statements, sir.
Do you recall in the opinion where Judge Randolph found Attorney Bowman's performance in those interviews that she was represented by a seasoned and competent attorney?
That sounds familiar, whether I saw that in the appellate brief or I saw that somewhere else. But that quote that you are providing to me sounds very familiar.
So you have no reason to doubt it, that he said that in the opinion. In his memo of decision, you have no reason to doubt that that's what Judge Randolph stated.
Oh, of course. You're a member of the bar. You're not going to misstate that to me.
Okay. And he actually said it twice. He said it in the body of his opinion about that Attorney Bowman was competent, and then he said it again in the conclusion of that opinion, right?
I don't have the opinion.
Do you have any reason to doubt that?
If you're telling me that Judge Randolph said it twice, then I accept your representation.
Okay. As an officer of the court, correct?
Yes.
Okay. So in you said compensated for your testimony today, correct?
For my time.
That's an answer, Your Honor.
No, I'm asking.
I'll allow fair cross-examination.
Okay.
You are getting compensated for your testimony today. That's what you testified to on direct exam, correct?
I'm being compensated for my time.
Okay, for
not
your
my testimony.
Okay, you're not being compensated at all for your testimony today?
My testimony is my time.
Okay, so you're being compensated for your time, right?
My time.
Okay. And part of your time is your testimony, right?
Of course.
Okay. How many hours did you spend reviewing in this particular matter when you were hired by Attorney Brown? How many hours have you spent reviewing the materials in this case, and reviewing the videotape, reading the transcripts, police reports, all of those things?
Since November 21st, about 85 hours.
Okay. And again, you're billing at $3.50 an hour?
Yes.
That also includes your time sitting in court all day Monday watching Attorney Bowman testify, right?
That's correct.
Did that include travel time from Bridgeport up to Rockville?
The 85 hours does not include travel time.
You just kind of throw that in there?
No, that's going to be billed separately.
Okay, but you're going to get compensated for your travel time at some point, right?
Yes.
Okay. So if you're being billed at $3.50, if you're billing at, you said what, 85 hours?
Yes.
So let's see, 85 times $3.50, right? And does the 85 hours include your testimony today, today's proceedings?
I was up to about 85 hours as of last night.
Okay. And so you've been hitting, we started today roughly around 11. You were here what time?
I was here at 9:30.
Okay. So from 9:30 now, and it's 4:45, you're still being compensated, right?
That's correct.
So far, excluding today, you were making $29,750 today being paid by Attorney Brown through the Troconis family, right?
I believe so.
In addition to all the thousands you made, Mr. Schoenhorn, right?
Correct.
Now, with regard, you saw the witness list in this case, correct?
That's correct.
Okay.
Well, I take that back. I don't know if I saw the witness list in this case.
Okay. Let me back up a minute.
Okay.
You said you have been a member of the bar since 1987.
Correct.
And you've known Attorney Bowman since you became an attorney at that time. At least you knew of him. Fair enough?
Yes.
Okay. You understand that he's been a member of the bar since 1970.
It's remarkable.
Okay. But is that a yes?
That's a yes.
Okay. So he's been a member of the bar for about 55 years. Fair enough? We're in 2026 now.
Correct.
Okay. Your office is in Bridgeport, right?
Yes.
And his office is in Westport, as you know, right?
Yes.
Okay. And your office has been in Bridgeport for quite some time, hasn't it?
Yes.
Okay. And so has Mr. Bowman's office been in Westport for quite some time.
Yes.
You're aware of that? Okay. So your offices are really not that far from each other, 2 towns over, right? You got Bridgeport, Fairfield, and then we get to Westport, right?
That's correct.
Okay. Did you ever reach out to Attorney Bowman at all in this case?
No.
You did not.
No.
Was there any legal prohibition from you doing so?
Was not part of the mandate.
Okay, I'm asking, did it ever occur to you to reach out to him?
Never occurred to me.
Okay. Had you reached out to him, and assuming for the sake of argument, he was willing to talk to you, you would have had a more informed basis about his performance in this case, having gotten his side of it.
It's just something that an expert would not do.
I'm asking
Not
you,
part of the mandate in this case.
put the mandate aside. I'm asking, you knew him for a long time. You know how to reach him. All right? You could Google him and find his phone number on Google where his office is. Did you ever make any attempt to reach out to him? You said no. If you had reached out to him, and assuming for the sake of argument, he was willing to share information with you, do you agree with me that your opinion about his performance might be more informed because now you're getting his side of it and what his strategies were?
Speculation.
I think it's fair cross-examination.
Fair enough. Fair enough, Attorney Fitzpatrick?
Do I think that my opinion would be better informed
Yes.
if I had spoken with him
Right.
to find out why he did the things he did?
Yes.
I suppose that's possible.
Okay. So that's a yes. Right?
Yes.
Okay. Did you ever ask for his notes?
That would not be something an expert does. That was not the mandate.
Now, you would agree with me, having testified, I think you said in 11 habeas cases as an expert, right?
I've been the expert in 11 habeas cases. I'm not absolutely certain I gave testimony in every single one of those. I would say 10 is a safe number.
Okay, I just want to be clear. I don't want to misrepresent your testimony. You've said you've testified in 10 habeas matters, right? Fair enough around that?
Yeah, well, approximately.
I'm not going to hold you to it. Does that sound about right?
Yes.
Okay. And all but one of those, the court granted the petition, right?
In all but one, the court granted the petition?
Yes. The petitioners on the ineffective assistance of counsel claim, right?
You're saying that
I'm sorry, withdrawn. My mistake. I misspoke.
what you mean to say is in all but one of those,
They denied. My mistake. I
Yeah.
misspoke.
Yeah.
Okay, let me rephrase it again so the record's clear. That's
Sure.
my mistake.
Yeah.
You've testified in about 11. I'm not holding it to you. Okay.
Right.
All but 10 were denied, right? To your knowledge.
I don't know what the court did. Believe it or not, I don't know what the court's ruling was in all of those cases, except the Skakel case and maybe a couple of cases that I followed up on with habeas counsel.
Right. Weren't you even curious about what happened to the others?
Yes, and when I run into the lawyers in court, I usually say to them, "Hey, what did you get? What is the status of that habeas? Did you get a ruling yet? What was the outcome?" But I don't hang around the courthouse to find out. I don't call or write the lawyer and say what was the outcome.
Well, couldn't you just go on the judicial website online and look what happened?
I could, but I don't have that kind of vested interest in these cases.
But you had a vested interest to testify as an expert?
I have testified in an expert in the cases that I thought were worthy prosecutions.
We just have a moment.
Yes, is this a good place to adjourn for the day?
Well, when you put it that way, I guess it's, yeah.
Well, if there's one or two follow-up questions on the same issue, I would certainly allow that.
There's no question pending, Mr. Fitzpatrick.
Okay.
Okay.
Yeah.
I mean, you know how the proceeding works, right?
Yes.
So you would agree with me that in a habeas proceeding where you've testified as an expert about 11 times,
Yes.
that one reason why we have a full-blown trial relative to a claim of ineffective assistance of counsel is to augment the record to see why counsel did what he or she did.
Objection. The purpose is to educate the court, not the expert.
Right. Well, this does venture into a new topic, so I'm going to say that we'll adjourn for the day. And I'll see counsel at the sidebar, Mr. Fitzpatrick, if you check your calendar, and we'll decide whether it's Tuesday or Friday that we resume. Okay, so
Yes,
Marshall
sir.
will adjourn for the day.